759, and that was on September 4th of 2019. Within that screenshot that I sent to them, Friday and
Good
then we sent
morning.
it this morning.
Sorry I'm late. I got
Was photographs
caught up with some
of
business
the
stuff.
defendant taken at that time. At their request, shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Oh, strike that. 192473549_GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
Well, we're not necessarily seeking redactions, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres, one seems to focus on Ms. Boone, and there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in the shower for bath to bath. And so some of that's redundant, but there are actually 2 separate videos pursuant to the 5th.
Mr. J, are there 1 or 2 videos that the state's seeking?
There's one, the one that I listed, filing for non-important order.
Okay. Do you know if that's a... Bruce, can you find out what counsel's here for? Is that the video from the perspective of, as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Okay. Mr. Beck, the specific file number was identified. So just to confirm, no redactions? Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are 2 911 calls and 1 body-worn camera sought by the state to which the defense has no redactions. The August 28, 2019 incident for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the 5th event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday. How that list was culled down and the additional pages that the state was seeking. And then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense, that the state wanted extension out of rule of completeness. I believe we're...
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in, those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
I'm not sure it exists, Your Honor. That's what we're saying.
But if it's going to be moved into evidence, we have is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that you're, if it's an electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages just to confirm it. Lastly, with regard to hospital records of the victim, I know there were conversations and discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital records for the victim, Jorge Torres.
That's my understanding.
We need to do that, Judge. We've got to do that.
Okay. My understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
The second expert is not likely to testify until Thursday. She's testifying in Bay County tomorrow. I will be here Thursday. I spoke with Dr. Brandon last night. He will be present tomorrow morning as soon as he gets here from Coral Gables.
Did either Doctors Brannon or Harper rely on those medical records?
Dr. Harper did. It's in her deposition that was taken a couple of weeks ago. I think the question was posed.
Ms. Perez, good morning. If you're here for pretrial, 19 Alpha, Judge Myers is covering.
I went up there.
Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of Jorge Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. Of course, she was asked by the state about everything that she relied upon, and she did indicate that. Are we going to use or attempt to introduce those records? We'll pare it down if we are.
Okay, you've got till 5 p.m. today to advise the state as to what of those culled down records you're going to be utilizing. So they have the opportunity to review those in advance of Dr. Harper testifying.
And I apologize to Madam Court Reporter for speaking on top of each other. Dr. Brandon is testifying as a subject matter expert who does not have specific familiarity with this case. And so there are no medical records or any other records that he has relied upon other than his knowledge and expertise.
Okay, all right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay, all right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers to review it, for us to discuss it, and to see whether or not it has merit or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Mr. Owens, at 9:38 last night. I'll give the opportunity to review that, and we can address it after the lunch hour. And that'll give the court the opportunity to do any research during the lunch hour on it as well. All right, anything else, Mr. J, that,
I looked at it briefly. I'm not for sure exactly what the allegation is. I don't know if we need to talk about that. So excuse me?
I'm not,
Can we approach the bench?
sure, come on up, yo.
Well, we're going back to the bench. Well, she's really engulfed in all them papers, ain't she? You know, some of these cases can be pretty crazy. Some of them are very emotional. And then there's some that just turn into an absolute damn circus. But tomorrow night, I'm going to stream the trial tomorrow as well. But tomorrow evening, I think I got it scheduled for 5:30. Let me look. Well, it don't tell me. At 5:30, yes, tomorrow, Central Standard Time. I'll be going live and discussing another legal issue that has come up where some creators, along with a father of a victim, as well as a business, an LLC, along with, some bigger people, have filed a lawsuit claiming RICO activity against two named defendants, excuse me, and 50 unnamed defendants. We'll go over the filing, the court documents. If anyone that's knows more about this or whatever, if they would like to come on and talk, I'd be willing to open up the panel. I don't have a problem with that. And it doesn't matter if I agree with your behavior or not. I'm not going to be ugly to you. I adhere to my ethics. So I want to have, and my intent is to have a safe place for folks to talk, where they're not in fear of their opinions being dissected and just manipulated to fit what other people want. So, but we'll see how tomorrow evening goes, and if somebody wants to come on and talk about this, I have no problem sharing the link. But I'm not going to allow it to be.
All right, thank you all very much. With regard to that motion, we're going to table that for now and address it potentially this afternoon. State is advised they're ready to proceed. Mr. J shook his head yes. Defense, you ready to proceed? Mr. Owens, you ready to proceed, sir?
Yes.
Thank you. All right. Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
But what I was saying is I'm not going, if someone comes on, I'm not going to allow for there to be any bad mouthing, belittling, or anything like that. We'll talk about things, but it needs to be done in a respectful way.
Jury entering.
Oh, I've got my coffee. Do y'all?
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Go get it.
Everyone would be seated. Thank you.
The show is starting.
Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
Ma'am, good morning. Again, could you state and spell your name for the record?
My name is Chelsea Kepsel, Chelsey, Koepsel.
Mr. Cacciatore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving. Is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who was your partner that day?
Detective Scott Lowen?
And throughout the whole time, you and Detective Lowen worked on this case together, is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including, like, deputy sheriffs, like in uniform?
Yes, ma'am.
Yes, approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
All right, so that had already been done by the time that you arrived, is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses, is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone, is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it, is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement, is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it, is that correct?
Yes.
Okay. All right, so, and out there, that's part of talking to witnesses or potential witnesses. Okay, also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
All right, and in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right, and was Miss Melissa Roffengarden, is that how it's pronounced? Pronounce it for me.
Rough Garden.
Rothgarden, okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I initially arrived on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures, And then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted, to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct, or pictures, or actually collect and take away. Is that correct?
Yes, that's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically. But that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes,
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
yes.
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And also the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
All right. So out of the items that were collected at the house or the apartment, at those items, was anything, to your knowledge, sent off for further examination?
I believe so, but if it was, there would be, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time, there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone? Is that correct?
Yes.
All right. In fact, that was done on her interview date, on the, would it have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of George Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay. Yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it I would request it to the crime scene investigator, and she would, author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question
okay.
about it, okay? All right. But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done, okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres' autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
Okay. And did you communicate with the medical examiner at that time?
Yes, I did.
Okay. During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own, something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay, so after the autopsy, you had additional information, is that correct?
Yes, I did.
Okay. Now, there was an interview, well, I don't know if it was an interview, there was a meeting set up for Sarah Boone, is that correct?
Yes,
On the 25th? Is
Yeah.
that correct?
yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification. And I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy. And then obviously from watching the video, towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving, we're going to make next of kin notification. She was very concerned about that, so I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone, is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry, did she give you permission to take the phone?
Yes.
Okay, is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone, is that correct?
No, it was based off of consent.
Okay, so she had consented to you to, for you to have her phone, is
Yes,
that correct? She also provided you the code to get in the phone, is that correct?
yes,
So at this point in time, Ms. Boone is cooperating with you, isn't that correct?
yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it, and those videos were found, I felt like this was very different, and it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be, basically, like I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until, I didn't submit it until the next day. And then it was signed the next day, on the 25th.
So basically, what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received, is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could go through I knew I could get a search warrant to go through the phone based off there being evidence. like the 911 calls, and her explaining to me that they had spoken to family members,
Please silence your cell phones.
since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented, and she could have not signed the paper consenting while we were on scene.
But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay. So, did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific, if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 25th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day. Or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her, set up this meeting with her. Is that correct?
It's one or the other that
One
I've.
or the other?
Yes.
Okay. As to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Is that correct?
it was a summary, yes.
All right, as far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to, not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, or they train you that your reports should be very much in detail. Is that correct?
Yes.
Okay? Because you might have to refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, and to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down, and where did y'all meet?
The Orange County Sheriff's Office Central Operations.
All right, to meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report. report.
Okay. Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am? Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at this time, at that time?
Yes, I was.
Okay. All right, well, anyway, Ms. Boone, there was a meeting arranged, is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting?
She
on the
did.
25th?
Yes.
That we saw, okay. Now, ma'am, I'd like to talk to you about some other investigation. On witnesses, other witnesses that you took their testimony or statements, recorded statements at different times. Okay? Do you remember Abraham Moreno?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Moreno's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
All right, I would again object. She hasn't indicated that she needs assistance with her memory.
Approach. Objection sustained.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you. Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent, do you know his last name?
I would butcher it.
Me too, but Taglione, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then, did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Okay. Now, let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this to relevance.
Approach. Objection's overruled.
So ma'am, at that time, you did not tell Ms. Boone, prior to coming down there, that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
We planned to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her?
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, like physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Ms. Boone shows up, and you tell her there's some things that we need to talk about. Is that correct?
Specific verbiage, I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings, is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings, is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Ms. Boone wasn't under arrest, is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Ms. Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview?
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a reason, could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach. The objection is sustained.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people, such as Ms. Boone, or well, let me specifically, in the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
I confer, Judge.
Yes, sir.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
State, any other witnesses, evidence, or testimony to be produced?
All right, this time the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address. So we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given to you over the last couple of days. Please do not discuss this case amongst yourselves or anyone else. Do not conduct any independent research or investigation as to the person, places, things, or charge involved in this case, and we'll bring you back in as promptly as possible. Thank you.
Jury exiting.
Okay, I'll do some legal for me.
You all may be seated. Thank you. Defense, any motions?
Judge, we do have some motions, but my client needs a comfort break.
Okay.
If we could do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you. We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Yes, sure, on behalf of the state, William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Do we have any motions?
We do, Your Honor.
You may proceed.
If I may approach the podium, Your Honor.
Yes, sir.
Your Honor, at this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit. I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially has assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize, I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or an imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented testimony, an argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that in fact that she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response?
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact in taking all the facts in the light most favorable to the state and the inferences drawn from them establish the elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Ms. Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m., 45 seconds, should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing, is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events. And therefore, we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement, both on the 24th and 25th, that I have no idea what happened. I just went to sleep, everything was good. And then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
All right, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last, call whatever witnesses, put on exhibits, photographs, and then the client would be the last person to testify. Because of the nature of this charge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, and the court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on, and based on that denial of that motion for judgment of acquittal, to just go through it again, because I know you're gonna ask to colloquy about all that. So, I'm gonna need a few moments with, I don't know if it's 10 minutes maybe, for the 3 lawyers, 4 lawyers, to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
Okay, off the phone. Yeah, this is, well, like we see scrolling across the bottom of the screen, they're going to call Sarah Boone, and I'm guessing she'll be the first one up. Um, I don't know. Is this going to be the only person that the state calls, or the defense calls, rather? This is going to be interesting. But I do want to thank you guys for joining me. But I guess we'll see what all happens when she gets on the stand. I really, I really do wish she had taken the deal. I really do. But I guess we'll see what the jury has to say.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Kester on behalf of the state.
William J. for the state.
Defense?
James Owens from Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering in the affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior incidents of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about that.
Okay, then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is, I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at the bag. And then the third thing is that the state had filed that motion for the in-camera hearing. I don't know, maybe we need to hear that before she testifies?
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that Jorge Torres committed on Sarah Boone, and there's a dispute about whether or not I have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence, or she took action to either block or physically restrain Jorge Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that Jorge Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose some of the acts that had been committed on her by Jorge Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video, and so I think I can talk about the prior bad acts before the event in question chronologically, and I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020, before go into reputation evidence, prior instances of violence, or matters of syndrome evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence,
Any particular reason why it hasn't been done in the last 45 minutes?
because
When I sent my jury out?
I've been meeting with my client about
Okay.
her rights to testify or not, and other related matters. So in terms of not giving her this evidence,
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment? It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits, and along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand by, bring it back in our panel.
Jury entering.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Jury exiting.
Well, looks like we're going on an early lunch.
Y'all may be seated. Thank you. State and the defense, if you could please review those items, and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you.
So we'll be on lunch until 1, which will be 12 Central Time. So Wow. I can't believe she didn't take the plea deal. Really wish she had of. And now I can't believe she's actually going to get on the stand and testify. But I'm not surprised, to be honest. I'm not. So, oh well. It's what it is, I suppose. But I appreciate all you hanging with me today. This is a wild case, guys. It's just wild. And we'll see how it goes with her on the stand. Should have known though that she would get on the stand. I should have known since she did earlier in one of the motion hearings, but because I mean she wants her day in the spotlight, so well. It's crazy, isn't it, Casey? It's just absolutely crazy. So, it is what it is. Yeah, this case just really blows my mind. A lot of things about it. But, you know, it's... I mean, my biggest thing is, you know, she was sitting there videoing it. I mean, why waste the time? I kind of figured she would too, Casey, in a way, especially when she was representing herself. But, excuse me, when she got this attorney, I figured, well, maybe they'll kind of steer her out of that, but I guess not. I think these attorneys, to be, you know, in all honesty, I honestly feel that they're just there to make sure that her rights aren't trampled on. I mean, we all know that the battered spouse syndrome isn't going to hold up. I really, because at that particular moment, she has stated many times that they were having a good day. So that battered spouse syndrome, which, I mean, I guess she could be like, well, I didn't want to let him out after that point because I was afraid of what would happen. That could be one, but I don't feel like there's been enough shown to prove that. I mean, it's an accident. I don't think she meant to kill him like that or for him to pass. I don't believe that she meant to do that. But then again, there's text messages where she says she's going to get rid of him. I mean, so that's the messed up thing with all of this is we don't know what's in someone's head, and we have to just go by the evidence and stuff that is presented and how it's presented. And that's what court is all about, is, you know, which side presented the best case, so to speak. So yes, I mean, I do agree with that, Casey. That video shows her as a spoiled child. However, it also shows someone intoxicated, highly intoxicated, that has experienced a lot of trauma at the hands of the person that's in that suitcase. I mean, they both had been arrested in the past for DV. So I don't know. These cases are so hard because it's like you always want to believe the victim, but just because we wouldn't do something like that doesn't mean that this person felt as if that was the only option. So hang on just a moment. I just got a message I need to. Okay, give me just a moment. I gotta send some emails real quick. I gotta do some work real quick. Hang on just a moment. I'll be right back, guys.
We are on the record,
My
20.
client's not here either.
We'll wait for her. That's fine. Just hang out for me. We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Ms. Boone.
Ms. Boone is seated at counsel's table, wearing the same black jacket and blue blouse from this morning. We will be standing when our jury enters. She is in custody but out of any restraints. As she is testifying first, once we bring in our jury, she will walk to the jury box and be sworn in front of the jury. State, are we ready to bring in our panel?
Yes, Your Honor. I was able to get the redactions done. I put a disc on Mr. Owens' notebook there. Has the case number on it and 3 black dots in Sharpie, just so that a random way of saying what it is.
Excellent. Appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
Number one, Kevin Beck is working on,
Let the record reflect that Mr. Beck has appeared.
for the record, I'd like to make 2 points about this issue, about whether or not I can bring in evidence of prior acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so. One is, Judge, in that 2-minute video, Sarah Boone makes a statement, "That's how I feel when you choke me." And then some moments later, "That's how I feel when you cheat on me." And she's angry at him, and she's talking to him. She's talking to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to when you choke me. That's my first motion.
Okay?
The second one is, Judge, on this.
Before you proceed with the second, is the second intertwined with the first?
No, I mean, it's a similar argument, but it related to something else.
Okay, response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law in Oklahoma.
Any other further arguments, sir?
Not on that issue.
Motion's denied. Court, again, is going to rely on the Supreme Court's guidance in these situations based on Holland 916 Southern 2nd 750 at 1.760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of George Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of George Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when George Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent. So she knew when he brought home that second bottle of wine that it was not going to be a good night, and she tried to keep him occupied and tried to keep his mind off of his troubles, because she knew that if he reaches a certain level and is dwelling on his hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his overt act, which she's going to testify to, coupled with the fact of her state of mind based on her past experiences with him in that intoxicated state and the fact that he is violent. So she was hypersensitive to danger and fear. And I think that ought to be allowed in as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically restrain George Torres in the suitcase, to actually use the bat to prevent him from getting out of the suitcase because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? Based on
Well, there's
her
an overt
knowledge.
act committed by George Torres, but she was heightened because she knows when he gets to that level of intoxication in that scenario, and that's an issue.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable, Judge, due to that due to his degree of intoxication, that he may act violently towards her. And the problem is, a lot of the problem is, Judge, he doesn't remember battering her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him. But she's tired of being beat on, and so that all ties into her behavior, her sense of nervousness at that point. The reason she was so confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
We held these arguments already. The court has ruled. There are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act has to be something that is objectively reasonable to cause a reasonable person to believe there's an imminent fear of great bodily harm or death. What the testimony is not that that's what has occurred, that there's, her new testimony is this generalized fear, but you've already read that and you've already ruled on that. And I'll just remind the court that her previous testimony is, it's all fun and games, we're laughing, I zipped the suitcase shut, we're still both laughing, it's funny, and then the decedent says, I can't breathe, and then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe, and then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. We've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt act. She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you, and I say, give me everything you own on you right now, and then you, in turn, pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that, you pull a gun on me to defend yourself, and then I shoot and kill you, I can't assert self-defense. I can't say, well, Judge Kranick pulled a gun on me and I was in fear of death, because I was the initial aggressor, I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies as she previously has, the court has already ruled there's no overt act, and you've read the transcripts, you know what she has said.
Judge, she hasn't testified. She hasn't testified. Dr. Harper's testified. Dr. Warner's testified.
They have not testified. They've given depositions.
Well, given depositions, but she hasn't testified about the act in question. She hasn't testified about the event in question. She had consultations and evaluations by Dr. Harper where they had discussions that Dr. Harper could relate in her testimony. Dr. Warner can say what was said during the evaluation. Again, both of those were not reported. There may be disputes. I disagree with his characterization of that assessment. But it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. She's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those inconsistent statements.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine, and I know what happens when he gets it, and everything that follows from that, those are bad acts. That is character. And the Florida Supreme Court has provided guidance in circumstances, specifically in Holland, on what needs to be done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. That's all prohibited character under 404, 9404. And the carve out for that is if a overt act is established. It's not a subjective standard, it's an objective standard. The jury instruction, 3.6F, identifies it being an objective standard, and the Akendo case specifically tells us that it's an objective standard. In Akendo, the second DCA in 2023 stated, the conduct of a person acting in self-defense is measured by an objective standard, but the standard must be applied to the facts and circumstances as they appeared at the time of the altercation to the one acting in self-defense. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything
She
else?
understands we cannot talk about any prior bad acts or anything of that nature until we talk about the actual event, the attack. Correct? You understand?
Do you understand that?
I do.
Okay. Anything else, State?
No, thank you.
Defense, anything else, sir?
No, sir.
All right, let's go ahead and stand and bring in our jury.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. Y'all can be seated. Members of the jury, after seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. With that, state has rested. The defense is going to put on a case. Defense, Mr. Owens, you can call your first witness.
The defense would call Sarah Boone.
Raise your right hand, please sworn. Please do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, you could take a seat. And if you could, state and spell your name for the record for us.
Sarah Boone, 101077.
And could you spell your name?
SARAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
I was born in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay. You all moved down from Atlanta down to Orlando?
Yes, and my 2 brothers.
Okay. And were you raised here essentially from that time on?
Yes,
And you resided here in Orange County, Florida that entire time?
yes.
Okay. And where did you go to high school here locally?
I did.
Where did you go to high school?
Edgewater.
Okay. And tell the jury, how old were you when you graduated?
I was 18 years old.
Now, I know you lost your mother and father.
Overruled.
I know you lost your mother and father in your teens and in your 20s. Is that true?
I lost lost my grandfather when I was a sophomore in high school, and I lost my father when I was a senior. And then my mother passed away a few years after that, and then my grandmother passed away after my mother died.
All right, so you were in your 20s when all that was going on?
Yes,
Okay. And then at some point in your 20s, you met Brian Boone?
I did, yes.
All right, and how long did y'all date before you married?
A good handful of years. I helped my family with paying mortgage and bills for the house since my father had passed away and my grandfather, so
So you worked outside the home?
I did.
Okay. Can you tell the jury when you said you and Brian Boone dated for a while? Do you remember when y'all married?
I do.
Could you tell the jury when y'all were married?
The year?
Yeah.
Um,
You remember the date?
It happened to be, yes, that after my mother passed away, that he had waited to ask me to marry him because he knew it would be, I would,
Objection, non-responsive.
Sustained.
Just answer the question if you can, Ms. Boone. Are you a little bit nervous?
a little bit.
Okay. Well, just tell the jury if you remember the date that you and Brian Boone married.
August 21st, 2004.
Okay. And had y'all lived with each other for a short time before that?
Short time.
Yes. Okay, after you married, how long was it before y'all had any children?
Gosh, 6 years?
Okay. And y'all have one son.
Yes.
What's his name?
Lucas.
And how old is Lucas now?
Lucas will be 14 years old on the 28th.
28th of this month?
Yes.
So you and Brian were married, and y'all lived in Orange County. How long were y'all married?
For 13 years.
All right, and y'all divorced?
Yes.
And as part of the divorce, were y'all to share custody of your son?
Yes.
And so y'all would split days, would that be fair to say?
Yes.
At some time after you and Brian split up, did you meet Jorge Torres?
Yes.
All right, could you tell the jury how you met Jorge Torres?
I met George when I decided to buck up, I guess, and was tired of trying to patch things up with my ex-husband. And I decided to go one day for a walk across the street and go have a beer by myself and sit and people watch just to get out of my house and a change of scenery.
All right, now is this your apartment?
No, this is the marital home.
Okay. Where is that marital home?
Winter Park?
You're no longer living in that marital home?
No.
Who lives in the marital home?
No, when it has been sold.
Okay. So you met Jorge Torres before you got the apartment?
Yes.
Okay. And you met him at a bar across the street from the marital home?
Yes, we had a mutual friend there.
Were you introduced?
Yes.
All right. How did you and George get along when y'all first met?
Very well. It was strange how quickly we hit things off and had so much in common, and I never thought that he would be interested in someone like me, and I just couldn't believe that he was actually interested in me and said a lot of nice things, and 1 hour ended up being 4 hours from when we had first met, and then we would always have something to talk about.
Why couldn't you believe that he would be interested in you?
He was very handsome. He was very funny. He was smart, and I would show up in workout clothes and disheveled hair, and I guess I kind of felt broken from being in the process of the divorce that he knew about. But then one of the things that we could relate also was the fact that he was here in Florida because he had just been divorced from his second wife. So that was another topic that he and I could compare notes on.
So eventually, the divorce was settled. Did you get your own place?
Yes.
Is it fair to say that after at first you lived in your parents' home, correct?
Yes, until I was married.
And then you moved directly in with Brian? And then y'all lived in the marital home, correct?
Yes.
And then you got this apartment.
Yes.
So that was the first time in your life that you actually had your own place.
Yes.
And what was the address?
4748 France Court, apartment number 3.
And what city is that in?
It's in Winter Park.
How far is that from here?
20 minutes?
Okay. So you got that apartment, and initially, were you by yourself?
No.
All right, tell the jury.
In the almost year, about 10 months of separation from Brian, my ex-husband, that is the time when I met George. And my ex-husband was trying to buy me out or force me out of our marital home, and I needed to find somewhere to live. And
So did you and George agree to rent the apartment?
yes, I needed extra income. We could not afford it, just on my own.
You were receiving some income from the marriage settlement, were you not?
Yes,
So you did have consistent monthly income coming in from the marriage settlement,
for the most part, yes.
but you needed more to live.
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills and on a regular basis where it wouldn't be something that I would have to argue with him about. It would just be an automatic, make sure that everything's paid first, and then from there, hopefully have some fun with it.
Okay. So I understand from that point on, would it be fair to say that y'all saw each other on and off for about the next 3.5 years?
No, I would consider us a couple.
Okay.
At some point, he asked me to marry him.
Okay. But y'all did have times where he left and went to live with his parents?
Yes,
Is that fair?
yes,
And there were times where there was an understanding that y'all were going to break up?
multiple times.
Okay. All right, so, again, on again, off again.
Yes, this was actually before we had our apartment. That was, I guess, our dating phase.
Okay. So y'all were together for 3.5 years, is that fair?
Yes.
And y'all had actually agreed to marry?
He had asked me, yes, a couple of times to marry him, and one time I agreed to yes.
Okay. Now, I want to get directly to the date of this event so that the jury can hear your testimony. All right? So tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day, from the time y'all got up, the whole thing.
Approach. Objection's overruled for now.
Now, Ms. Boone, let's just, instead of one long speech, let me break you up over the course of the day. So, do you remember the date of February 23rd, 2020?
Yes,
Do you remember getting up?
yes.
All right, just tell the jury about that morning, what y'all did that morning, what you and George, you and George spent the night together at the apartment.
Yes, at that point, he was living there.
Yes. So y'all slept in the bed together upstairs, February, so you would have gotten up, y'all would have gotten up that morning, February 23rd of 2020.
Yes.
All right, tell the jury what happened when y'all got up.
He was already downstairs, and I went downstairs, and he wanted to start the day off by drinking because it was a day off from his job. And I talked him into cleaning and tidying up the house for a sense of accomplishment. So that is what we did for however long that it took. So we did tidy up the house and got everything in order, and it was kind of a reward, I guess, to be able to sit and enjoy ourselves and sit on the back porch.
All right, what do you mean by cleaning up the house? What did y'all do?
We swept and mopped. We folded some of the laundry. I know that we did the dishes, emptied the dishwasher, just general run-of-the-mill tidying up.
And did you have your son coming the next day?
Yes, that was one of the reasons why we were able to do that.
What was the arrangement you had in terms of the next day would have been your day to pick up your son from school?
Yes.
What time would you pick Lucas up from school the next day?
I believe his school ended at 3 o'clock.
Okay. So you would have been responsible to pick him up, and he would be spending the night with you that night?
Yes,
So you wanted to have the house nice and clean?
yes.
How many bedrooms are in the home?
2.
And you and George had one bedroom?
Yes.
And who had the other?
Lucas.
All right. Is that exclusively his bedroom?
Yes.
All right, so how long would it have taken y'all that morning to clean?
I don't really remember what time we woke up, but maybe a good 2, maybe 3 hours.
Okay. And would it be fair to say that you and George both smoked cigarettes?
Yes,
And would it be fair to say that you and George both drink alcohol?
yes,
All right. So at some point, y'all finished your chores,
Yes.
right? And then y'all were going to enjoy the day.
yes.
All right, what was the plan?
It was just kind of, we've got the day to ourselves. Let's just kind of relax and go with the flow.
Did y'all make a decision that y'all were going to start drinking?
Yes, we had a half of a bottle that was already in the refrigerator, and I did not want to go out afterwards. I, again, had Lucas coming the next day, so we went over to Publix to purchase another bottle of wine, so we could not have to go out later on that evening.
Now, you were here in court when the state played the video of you two and the Publix purchasing the bottle of wine?
Yes,
Is that what you're referring to here with the jury right now?
yes,
Okay. And that was around noonish?
I believe so, yes.
Okay. Had y'all started drinking the leftover bottle before going to the Publix?
No,
Okay. So, y'all bought a bottle of wine?
yes,
All right. And how did y'all get to Publix?
my car,
How far is Publix from your apartment?
5 minutes.
How would you get there from your apartment?
What do you mean?
Did you have to go across any major highways, or is it right there?
You just come out of our apartment complex and you do a little U-turn and then you come up and it's right in that complex.
Okay. But it's easier to drive than to walk?
Yes,
Okay. I know at sometimes y'all would simply need cigarettes and it was in walking distance. Can you tell the jury about that?
yes. There was a AutoZone convenience store with, in the same, I guess, parking lot of our townhome, our complex. And it was just a straight shot from our apartment to a back gate, and you could get right into the convenience store from right there.
Okay. But y'all went over to get that bottle of wine around noonish, and how did you took your car?
Yes,
Did George have a vehicle?
we did not,
And how did you pay for the wine?
with my debit card.
And then y'all came back and started drinking?
Yes.
Okay, tell us what you did when you got back from the Publix.
Just went on the back porch where we usually spend our time because we're able to smoke cigarettes outside as opposed to inside. And
Is cigarette smoking not allowed indoors?
it is not.
Okay. Do you have pets?
Yes, I do.
Well, did you have pets?
I did, yes.
Okay. Were they with y'all there that day?
Yes, my dogs were with me all the time when I was there.
How many dogs do you have?
I have 2,
And just, what are their names?
Penny and Tess.
And what is the breed?
They are red Boston Terriers.
And are they both disabled?
Yes, Penny is blind and Teff is deaf.
So when y'all went out to smoke on the back porch and drink, I assume, as well, correct?
Yes.
Did y'all take the dogs out?
Oh, yes.
All right. Is there a place for them to do their business out there?
Yes, I extended our back porch for them to have a little bit of area as opposed to going from a large backyard from my marital home to our little townhome. And they would come out there and do their business, and I could sometimes I would open the gate and then walk them in the back part of our apartment.
So you and George were just going to enjoy the day together?
Correct.
Is it fair to say y'all don't have a lot of money?
Yes.
And so y'all were going to do something there in the home? Y'all weren't going out for dinner or?
Yes, we primarily, I would consider us homebodies as opposed to going out and partying and doing this and that.
Okay. And how long do you think y'all were out that afternoon outside?
A few hours.
All right. Could you tell the jury what y'all did during that time?
We have a dartboard that's out there, and we just had drinks, and we're just really enjoying each other's company and talking about, things upcoming, we both were looking for a job and just kind of, I guess, encouraging and supporting and planning. And
Well, now you said he had a job. Was he looking for a job, a second job?
no, the job that he had was very unstable, and at that,
So he was looking for something new?
yes, at that time, yes.
Okay. And so during that 2 or 3 hours, would it be fair to say that y'all drank the bottle?
Yes,
Okay. So would it be fair to say that y'all were feeling the effects of the alcohol?
yes,
Okay. At some point, who made the decision to come in?
I did.
Okay. Why did you want to come in?
I felt that George needed a change of scenery.
Okay. So y'all came in, and then did y'all do anything else before he left again? Were y'all doing anything? I know y'all did some arts and crafts. What did y'all do? At some point, he went to get another bottle at Publix.
Yes, I believe it was after it was right before, I believe, that we had gone inside. Because he called his daughters. I was trying to encourage him to call his family.
Okay, now where are his daughters?
His 2 daughters are located in Pennsylvania,
And what are their names?
Anna and Destiny.
And how old are they?
I believe that Anna is in her 30s, and Destiny may be in her early 20s.
All right, does he have any more children?
Yes, he has a son.
And where does his son?
He is in Pennsylvania also.
Okay. So part of that afternoon is y'all came in to call relatives, call family.
No, I had him call outside, just trying to, I guess, boost the mood. And the first daughter didn't answer, and I don't remember the reason I didn't speak to the second one. I believe if he did, it was just for a moment.
All right, now whose phone were y'all using?
My phone.
All right. And is that common for y'all to use that, for y'all to share that phone?
It was because George said that he didn't have a phone, so it would either be lost or given to him by his mother. So I didn't know he had a cell phone, so we would use my phone.
So it was primarily your phone?
Yes,
Okay. And you took a lot of photographs that were on that phone?
yes,
Videotapes,
yes,
text messages,
yes.
phone calls?
Yes, he and I both on the phone calls.
So he would use it as well?
Yes,
And that phone, is that the one that was seized in this case?
yes,
All right, so y'all called his daughters, and then during that phone call period, did you also call his brother?
Yes,
Okay, and which brother was that?
John.
All right, now, how many brothers and sisters does George have?
I'm gonna list them if that's okay.
Okay,
It's John, Pharrell, Isaac, Mo, and his sister.
okay. And do they all live here in Florida?
Yes,
Are they close by?
as far as I know, yes.
What about his parents?
Yes,
They live here as well?
yes,
Okay. But his ex-wives and his children live up in Philadelphia?
yes,
Okay. So you called the girls, then you called, or George called his brother.
yes.
Was that conversation that long?
No, it was not.
Okay. And then after that phone call, were y'all inside by this time?
Yes, at this point, I believe that it was a good time to get a change of scenery. So I thought George would be better off inside, and frankly, I didn't want to be outside any longer either.
Okay. So just to get an idea, about this time is when he went to get the second bottle, or did y'all stay inside for a while before he left?
No, from what I recall, I thought the day was over, and it was going to be, get ready for the evening, for the day, what do you want for dinner, do you have an extra load of laundry that you need to throw in, kind of thing, and that was my understanding, and he said,
This was about 5-ish or something?
I don't remember the time.
Okay. At some point during that time period, did George go to Publix again?
Yes, I thought he was going to be walking to the convenience store, but apparently, when he returned, he had gone across the street with my car and my debit card to buy another bottle of wine.
What was your understanding of where he was going?
To the convenience store, walking,
For what?
cigarettes.
Okay. And you learned obviously that he came back and you learned that he'd used your vehicle
Yes,
and he'd used your debit card
yes,
and he'd brought back a bottle of wine from Publix.
correct,
And you saw the Publix video of that.
yes.
So he comes back with the other bottle of wine, and did he want you to drink with him?
It was expected, yes,
Yes. And you agreed to consume the second bottle with him?
yes.
Okay. So over the course of that evening, drinking the wine, what did y'all do for time-wise? Watch a movie, music, just kind of tell the jury what you remember. I know it's obviously been a while, but
It was kind of a regular thing where I would always try to come up with entertaining activities for George, and I bought a puzzle. We started off at one point doing a smaller puzzle, and then we did that very quickly, so then I purchased a larger puzzle, and I believe it was 1,000 pieces. So I thought to get his mind off of things and to focus on something, it would be smart for us to do the puzzle. So for however long that took, we finished the puzzle. So that was one.
did you, every piece was finished, or was it?
Every piece was finished. It was strange that we couldn't find one piece, and we thought it was funny that it was like in like the perfect place on there. But yes, every one but one piece.
All right, after the puzzle, what did y'all do?
I decided to continue to maintain and focus him, and I have a bunch of paints that I used of my son's that his grandmother bought him. It's a very big art wooden box, and it's got pastels, pencils, paint, any kind of whatever. And he and I were very much into art, and with this resource, it got him very interested in being more creative.
How long have you been into art?
Ever since I can remember. As a child,
You like to draw?
I like to do anything artistic.
And I know, we saw some of the pictures of your apartment, but it looks like there was pictures and artwork up. Is that all your work and George's work?
The majority of it, yes, are belongings from my home, and then also some of George's, yes, on the wall.
Was he pretty good at art as well?
Yes,
All right, so you both enjoyed doing that.
very much.
So y'all got out Lucas's art set. What did y'all do with that?
We were just, I guess, doodling, you know, whatever. I would always tell him that everything that you make is a masterpiece. So just let loose and just let it go. And we would just paint and,
And
you know,
drink.
paint and drink, yes, and listen to music sometimes, and yes.
Okay. Now, with the dogs, did y'all get the dogs involved?
Oh, yes, my dogs follow me everywhere, yes.
Was there some dancing going on with the dogs?
Yes, after we had completed the puzzle and I guess we're painted out, I thought that it might be a good point for us to maybe listen to some music. And the music that George listens to is it's very fractious to me, and it was definitely not going to lighten the mood. So we ended up finding some channel on the radio, and he was feeling it. And then we ended up, my one dog gets very active and was dancing with us, and we were just having a good time listening to music.
And I guess it's getting pretty late in the evening.
Yes,
Anything else I've missed?
I don't believe so.
All right. So tell us where y'all ended up before you started the game of hide and seek.
We were there. I couldn't think of anything else possibly that I had to continue entertainment. But I remember sitting at the end of the couch and him sitting in one of my son's chairs that was in the living room, and just kind of doing this. Like, what are we gonna do now? Like, I very much would like to go to sleep.
Had y'all finished off that bottle that he had bought?
I don't remember, to be honest with you.
Bless you.
Would it be fair to say that as the day wore on, the more y'all consumed?
Yes,
All right. And would it be fair to say that as the day wore on, the more you consumed, the more effects you felt from the alcohol?
of course, yes,
Both of you?
yes.
Okay. So you would agree, would you not, that at the time y'all were trying to figure out something to do and you put your head on the couch, that would it be fair to say that y'all were intoxicated?
Yes.
Tell the jury what happened.
At one point, I guess he knew that I couldn't come up with anything else, tapped me on my knee and said, "You're it." So from there, I ran up the stairs and hid into our shower, just waiting for him to find me so we could hopefully go to sleep soon at some point. And
Now, your shower, is it a tub or just a walk-in?
it's a tub, but it's in the master bedroom, and you have to go all the way upstairs, you have to go in the bedroom, and then you have to go into the bathroom part, and then there's the shower part.
So did you lay down in the tub?
At one point, yes, I was.
Okay. So you were hiding?
I was trying,
Okay. And did you believe that he was going to come try to find you?
yes,
Did you wait?
yes, for quite some time.
All right, then what did you decide to do?
That I decided that I need to go to sleep, I'm picking my son up the next day, and we need to start wrapping up the evening. And I went downstairs to find where he was.
And what, I think the jury has seen pictures of your, would you call it an apartment or
It's considered a townhome.
a townhome? So you walk down the stairs, right?
Mhm.
And at the bottom of the stairs is a bookshelf here?
Yes, at the very end of it, yes.
Okay. So you walk down the stairs and you turn and look in the living room. What did you see?
I don't even think I made it all the way down the stairwell because I was just looking for him as soon as I could, to hopefully go upstairs as soon as we could. And I looked over and I saw him settling himself in the suitcase.
All right, tell us about the suitcase. How long, is it an older suitcase?
Yes,
Whose suitcase was it?
this is George's suitcase.
All right, and did he use it for traveling back and forth to Philly?
Yes, I had recently taken him on a trip to go see his children in Pennsylvania, who he hasn't seen in years, and we took that with us. And because of how dilapidated it was, how broken it was, in the end, after that trip, we decided that we would donate it.
All right, and I understand y'all kept the suitcase upstairs.
Yes,
How long did y'all keep it upstairs?
since we had moved in.
Is there a closet up there you kept it in?
Yes, it was in the master closet, the master bedroom closet, all the way in the back because of the size of it, and there was nowhere to put it, so it's all the way in the back.
So when did y'all decide to move it down from upstairs to downstairs? Was it that day or sometime earlier?
No, it was maybe a week or so prior.
Okay. And so what, y'all were gonna donate that to Goodwill, or?
Yes, we were going to do, I guess, a spring cleaning. Anyone who has children understands that they grow quickly, and there was a lot of clothes that I needed to go through of my sons, and then also from George and I moving in and just kind of putting everything in there, at one point where we just needed to actually go through it and organize it and get things more in order.
So is that the reason it was downstairs? You were gonna donate it and a bunch of things that you were gonna put inside of it?
Correct, yes.
Okay. So it'd been down there a week, so it was already down there?
Yes, George brought it down.
Okay. So you said that you got down there, you're looking for him, you see him settling into the suitcase.
Yes.
What did you do?
In my head, I said, oh man, we're obviously not going to be going to sleep anytime soon. And I walked over and he was trying to get himself flat, so I couldn't tell that he was in there. And then,
Now, let me stop you there. The suitcase, is it the suitcase over here in the
yes,
box? You've seen it, you saw it.
yes,
It's a pretty big suitcase.
yes.
How big is George?
George was my height. And
How tall are you?
I'm 5'3".
Okay. And how much did George weigh?
I thought it was 100 pounds.
Okay. And how much did you weigh?
I was 98 pounds.
All right. Do you agree you put on some weight?
Since I've been incarcerated, yes.
Well, at the time, though, y'all were pretty skinny.
Yes,
So from the pictures, it looks like y'all were both pretty thin.
yes,
All right. So because of his thinness, is that how? And he's a small man.
yes,
Okay. So he was able to get in the suitcase on his own.
yes.
Did he willingly get in the suitcase?
He was already in there.
Okay. When you got to him, did he see you?
Yes.
All right. Tell us what happened.
I mean, I zipped him up. We thought it was funny, and we're joking about how he was, I guess, small enough to fit inside of the suitcase.
All right. So what happened then?
From there, it was just, we were laughing about it, and it was just strange that he was small enough to fit in there, and then I kind of moved it around a little bit with him in the suitcase still. It was still funny that he was still in the suitcase, just, I think he and I were just kind of, couldn't believe that he could fit in the suitcase.
Did you eventually close the top?
Yes, well, the top was already closed. As he was settling himself in there, that's how I knew he was in there, was because the top was kind of flopping a little bit.
Okay. So he had got in there to hide, and he pulled the top
Yes,
on top of it. But you could tell he was in there.
yes,
You saw him right away.
yes,
All right. So at some point, did you zip him up? Did
yes.
you? And what was he saying or doing when you were zipping him up?
We just thought it was funny.
Were you both laughing?
Yes,
And so you zipped him up. Were y'all still laughing once you zipped him up?
yes.
Okay. Tell the jury what happened then.
From there, I moved the suitcase around a couple of times, just kind of on the wheels, and moved it around, and at that point, it was funny. We were joking and laughing about it.
All right, now eventually, did you go sit down on the couch and get your phone?
Yes,
Have I missed something?
Well, the suitcase had, from me moving it around, was flopped over. So while it was like that, I thought at that point I had a moment to, I guess, take the time to talk to him while I guess he was not able to get out for a moment.
So you flipped it, you got it on the top, right?
Yeah.
It gets in, but at some point you flip it over, so the zipper is on the bottom.
Well, it was just kind of how I was moving it around that it ended up kind of flopping, so,
And it was upside down.
yes.
So after you did that, what did you do?
That's when I went over and decided to videotape to just see the, I guess, the gist in it for him to understand that right now I feel safe and right now I have the ability to actually speak to you in a manner that normally I would not have the ability to do.
And you were intoxicated,
Yes.
and you would agree that you said some things you should not have,
Yes.
right? But you realized he could not get out and get at you. Is that fair?
At that moment, yes.
So it goes on for about 10 minutes.
Yes.
You heard it here today, did you not?
Yes.
You heard his voice as he was speaking from the suitcase.
Yes.
That was his voice on the video and audio.
Yes.
And you heard your voice on the video and audio.
Yes.
That was your voice.
Yes.
All those things said by the man were said by George in that 2-minute video.
Correct.
All the words said by the female were said by you in that 2-minute video.
Correct.
Were you intending on showing him the video the next day?
Yes.
At the time, or the next day, is it fair to say you don't even remember videotaping?
I do not.
So, from what you can tell from watching it, did that refresh your memory about that event?
I did.
Why did you say all that?
Mr. Owens, you may proceed.
about just the 2-minute video part that was recorded. Could you just tell the jury what you were feeling, what your feelings were at the time, and then just explain that to the jury? You mentioned, you talked about it before. You said he was in that confined space and it was my chance, but do you want to elaborate on that, or?
Sure. I want you all to know that the majority of the time, am always afraid and always scared.
All right, well, I understand that. Okay, I understand that. But would it be fair to say that you had some anger at that point?
I did.
Would it be fair to say that you wanted to tell him off to some degree?
I just wanted, yes, for him to have a better understanding, which was the whole point of the videos and documentation prior.
And you could tell that he was uncomfortable.
I'm guessing.
And did you want him to feel some uncomfort?
I did.
Okay. Now, at some point, you turned off the video.
Yes.
And then we saw a second video, which was approximately 11 minutes later. And you've seen that video that was played to the jury. It was 22 seconds long.
Yes.
And I don't think you speak in that video. You hear George say Sarah one time.
Yes.
Is that fair to say?
Yes.
So between the 2-minute video and the 22-second video is an 11-minute period. Would you tell the jury what happened?
We continued to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was, the things that he was saying very much frightened me, and cursing at me and threatening me. And
Did he want you to let him out of the suitcase?
I'm sure so.
Okay, go ahead, tell the jury.
And it got very heated very quickly, and he continued to push on the suitcase. And my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. And his hand started to come through, his hand started to come through this way. And so I shook the suitcase, trying to get his hand to go back in, shaking it, and telling him that, please stop doing this, please stop doing this to me, please stop doing this to me.
So his hand actually got out of the suitcase,
Yes,
and you went to the suitcase
yes,
and shook it.
yes,
Did that force his hand to go back in?
no.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes,
How long did you shake it?
I don't know.
But his hand was still out.
Yes,
Was he trying to get out?
forcefully, yes,
Was he angry at you?
yes.
Were you in fear?
Always.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was leaning up against the dining room table, right there.
How far was the bat from the suitcase?
3 feet, 2 feet?
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split-second reaction that I had, I happened to see that, and I grabbed the baseball bat and was trying to poke his hand to go back in, to please don't break through, please. So I hit his hand.
Did you hit the outside part of his hand?
Yes.
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
Now, you've seen the bat. It's a youth bat.
Yes, I bought it for my son.
Is this the bat you used?
Yes.
And you said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then
So the grip here,
prodded at it, yes.
you grabbed it with both hands here,
Yes,
and then the barrel of the bat, the big part of the bat is here.
correct.
And you thrusted it into the different areas of the suitcase?
I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did,
We've seen the photographs.
yes,
We see the bruising. Is that from that bat?
yes.
Eventually, did his hand go back inside from you doing?
Yes, finally, he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split-second decision.
Now, once he retracted his hand, do you remember zipping it up some, or what did you do in relation? Because he was upside down, was he not, at that point?
Yes,
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing, he wasn't threatening, his hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
You went back to the video and the couch,
I did, yes,
and we saw the second video,
yes,
the 22-second, and he's right side up again,
yes,
and you hear him say, "Sarah?"
yes.
Had you left enough room for him to get out? Zipper to zipper.
Yes, that's how his hand was trying.
That suitcase has two zippers, doesn't it? And they meet at various places along the line?
Correct.
How much room, when you flipped it over, how much room was between zipper to zipper?
I don't know specifically. I mean, it was enough to where his hand was coming out.
After you had hit him with the bat, was he not trying to get out anymore?
No,
Did you believe that he could breathe in there?
yes,
Did you ever believe he could die in there?
no, at all,
Were you trying to kill him?
never.
Did you want to kill him?
I did not.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
As long as he was in the suitcase, he couldn't harm you.
Correct.
When he's... Did you want him to calm down?
Yes, I wanted him to stop being angry because I know what it is for him to be angry.
You went upstairs. Where were the dogs?
The dogs ran upstairs with me.
And where did they go?
On the bed.
Did you have the phone with you?
Yes,
I know at some point you called your husband Brian, did you not?
I did.
Do you recall how long that conversation was?
Not very long.
Can you recall what was said?
I don't remember exactly. No, I don't.
One moment. Ms. Boone, Sarah Boone, you said that when he was in the suitcase, he was threatening you. Can you tell the jury what he was saying?
I don't know. Am I allowed to curse?
Yes.
But he was going to fucking end me. And that's what made me ask him please to stop doing what he's doing to me. That he was going to, I'm guessing, try his best that night to probably take my life.
But what, the threat you heard was
He's going to
say the
fucking
word.
end me.
Excuse me?
Fucking end me.
End you?
Yes.
One moment.
Yes, sir.
Judge, can we approach the bench?
Yes.
I don't know if you heard me or not, Casey, but I was just saying, I don't really know. I don't really know because I can also understand the fear that she has and how she would be afraid of him getting out of the suitcase because of the past DV amongst both of them. I get that, but at the same time, I don't know. I just feel
All
like
right,
she
members
could
of
have
the
left
jury, it is
and then
2:14.
called someone.
I have a matter
So-
that I have to discuss with counsel at this point in time outside of your presence. So I'm going to ask you to retire to the deliberation room. We'll bring you back in as promptly as possible. Again, similar instruction that I've given you. Please do not conduct any independent investigation or research as the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else about those things. We'll bring you back in as promptly as possible. Thank you.
Well, I guess we'll see what this is all about.
Y'all may be seated. Thank you. State, you can proceed with any argument at this point in time.
Judge, I believe that's pretty close to what we already knew from the deposition testimony, from the doctors relaying what she said for the proffer. What we have here is testimony from the defendant. Her timeline is She comes downstairs after having gone up to the shower and hiding, laying down, after being declared to be it. She comes back downstairs, and before she gets back to the bottom of the stairwell, she can see that the victim is in the suitcase trying to get flat because the lid is flopping, and he's not hidden just yet. And so she comes over, and I believe she testified she was moving it around before actually zipping the lid shut, but moving it around, everybody's laughing, it's all fun and games still. And then she zips it, and it's still fun and games, and everybody's laughing. And then at this point, she testifies that this is now her opportunity to get on her pulpit to express her true feelings about everything. And that's when she sits down on the couch and opens up her phone device and begins recording what later turns out to be IMG _1062.movie at 11:12:45 for 2 minutes and 3 seconds. During this period of time, the decedent is expressing meekly that he can't breathe. The only time he ever curses at her is, "Sarah, I can't fucking breathe. Babe, I can't fucking breathe." He is demonstrating under the law that he is in fear of losing his life. She has committed an aggravated assault. She has committed false imprisonment. She was the initial aggressor. There was no overt act to justify these actions that she took against her boyfriend. She then goes on to say that during this period of time between the end of the movie at 11:14:48 seconds and before the next one starts at 11:23, that it's now at this time, while he's still constrained and clearly unable to get out under his own power despite having his hand out, she begins beating him with a bat, poking his hands, poking the suitcase with a deadly weapon. A bat is used for baseball, but it can also be used to harm another person. And according to the medical examiner's testimony, there was great harm caused to him, deep ecchymosis bruises. She can't start to do this out of fear, like the analogy I gave earlier. If I pull a gun to rob you, Judge, and you pull a gun, I can't shoot you in self-defense. She started this. She started this. There was no overt act. And therefore, we're asking for you to prevent, under the case law, any prior instances of violence, any reputation evidence, and any battered spouse syndrome evidence, because that's simply just what the case ended up being. Thank you.
Response.
Judge, this was a game by two intoxicated people. When people are drunk and intoxicated, they do silly and stupid things. The evidence is uncontroverted that Jorge Torres willingly, by his own choice, elected to hide in the suitcase. By their interaction between the two of them, giggling and laughing at each other, he consented to her zipping up the suitcase. And the playful nature of what was going on during those few minutes prior to the video. When the video is turned on, there's a 2-minute period where they're talking. He's saying, "I need to get out, I can't breathe." She's not taking him seriously. As you've seen from the videos, I thought it was the boy crying wolf. She did not appreciate the fact that he could be actually having trouble breathing. And this was a chance for him to be heard by her about how she felt about some things involving their relationship. A short time later, the video was turned off, and then that period has been testified to by my client. And that period is uncontroverted. That's a second period of time. We've got that time for the video. We got the 11 minutes, we got the 22 seconds. And there's no video, there's no audio, there's no eyewitness, there's nothing but Sarah Boone's testimony. And she's testified here today that they had words, There were threats. He got his hand out of the suitcase. She knew by the threats and him getting his hand out of the suitcase that he was about to get out of the suitcase and he was going to hurt her. A reasonable person under that scenario would believe she was about to be harmed. She was an imminent threat of harm. She blocked that attack by grabbing the bat, hitting his hand. When that didn't work, she started poking him with the bat in the suitcase. Eventually, she poked him several times. He put his hand inside the suitcase. She put the bat up. When she realized he was not going to do that any further, she flipped him over right side up. She still had a fear, knowing that if he got out, she would be harmed. He would beat her up. She went upstairs. That is an overt act based on the discussions, coupled with the fact that he threatened her, using the word, "I'm going to fucking end it for you," or some words to that effect. I don't remember her exact words, just before she went upstairs while he was still in the suitcase. If she would have let him out, and this is now this is an event involving an omission, failure to act, failure to unzip him at that point, before she went upstairs. The failure to act, the failure to unzip, which would have let him out, which would have created a situation that she believed was imminent bodily harm to herself. Let's say that a police officer is called to a scene and the only thing he hears is there is a suspect and the suspect may be armed. So of course the officer pulls out his revolver and he's walking around. Well, then eventually he finds the suspect and the suspect reaches for his waist. The officer doesn't see the gun, but the officer sees the movement to the waist. The officer fires and shoots the suspect. The officer is justified because there's an immediate threat of harm. The officer has to react instinctively. There's no time to think. Similar to the actions that Sarah Boone had to take. Another example, you're in a bar with your buddies and you've had something to drink and another group has had something to drink and one of your buddies gets into an argument with one of the buddies on the other party. And one of your friends, seeing that it's being escalated and the guy that's arguing with your buddy is aggressive, more aggressive than your buddy is. Your buddy's trying to settle the thing, but this other individual, maybe he's had too much to drink and he's more aggressive. So you go around behind this individual, and before he's able to strike your buddy, you grab him. You lock him up. That's physical restraint to block an attack. Or you grab him by the neck and you choke him. Physical restraint to block an attack. That's what she was doing with the suitcase. If she let him out of the suitcase, she was going to be harmed based on him trying to get out with his hand, based on the threats he made while he had his hand out, and based on the threats he made while he had his hand inside just before she went upstairs.
Thank you. Court's going to re-review all the case law that it's obtained in its research in this matter and come back with an oral ruling momentarily. Thank you.
Yeah, Casey. I don't think it's a long break. I think this is going to be a rather short break. Um, it's 2:30 there, so this is probably the afternoon break. So probably 15, 20 minutes. So, but yeah, I don't. The one thing that sucks by watching this online is the fact that we can't see the jury. And I mean, I understand it because their identities need to be protected, but you know, if you can see the jury, then you can read them. And but well, but I don't think it's going all that great for her because she could have left. She could have went somewheres. And in my personal opinion, I'm not a psychiatrist or psychologist or anything, and I'm not, you know, but once he was in that suitcase and he couldn't get out, she could have left. And locking someone up in a suitcase is considered kidnapping because you're keeping them from freely moving, and that in and of itself is a crime. So I don't I don't know how this is going to turn out, to be honest, because no one was there. No one really knows what she was going through. No one knows. And I guess that's my biggest thing about the way that I want this channel to be is I don't want to be one of those channels that, oh, she killed him, oh, she's horrible, oh, she's, because I don't know what she was going through. I don't know what she has endured at his hands. I was in an abusive relationship, and not everything is documented. And you don't want everything told either. So, I mean, it's hard. These cases are really hard. But, it's sad either way because a family is without a member of their family that they care about and love. And her family is going through the same type of emotions because if this doesn't go in a favorable way, then they could be losing her too. Because I think she's facing up to life in prison. So, I don't know. But this case is going by a lot faster than what I thought it was going to go. I figured this thing would be drawn out. Okay, looks like we might have some movement in the courtroom. I saw the camera move. Right, Casey. Same with my situation. Nothing was documented. but we were one of the lucky ones because we were able to get out. So many are not able to get out. Okay, Casey. Yeah, I've got to get back up and get some more work done. You know how that goes. But I'll have it in my ear as always. Thanks for hanging with me today. I appreciate it. Here we go.
All right, we're back on the record. State of Florida versus Sarah Boone, case number 2020 CF 2603. Appearances for the state.
Chief Catch-Tor on behalf of the state.
William K. the state.
Defense.
James Owens for Ms. Boone.
Connie Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is currently seated at counsel's table, wearing the same clothing from this morning. Court has the opportunity to review the case law, review the arguments provided by both the state and the defense. Court finds that a overt act has been established. The case law is clear that a scintilla of the providing of an overt act is sufficient to provide the self-defense jury instruction. An overt act is not something that's specifically defined in Florida case law. It's something that's from the totality of the circumstances, seemingly under the authorities that the court has reviewed. As such, the court is going to find that under Holland, a overt act has been established and will allow the defense to proceed with evidence of reputation and specific instances of conduct and battered spouse evidence, so long as the necessary predicates are established for those items. Any questions or clarifications with regard to the court's order state? Defense.
I think it would help if we went through my exhibits involving the blow-up photographs and these other photographs, because I think some of it was contingent on the court's ruling. So I don't know if you want to try to deal with all of them one at a time in front of the jury, or whether we want to just talk about them ahead of time so that we know.
Are there any objections to those items?
It depends on the items. I was shown a lot of different things, including like a rap sheet between the victim and the defendant and stuff.
I've taken that.
We need to, I'm happy to take care of some of this stuff in advance.
I'd rather do it now
Yes,
so that it's not up, down, in and out with the jury.
so.
All right, go ahead, Mr. Owens. What do we got?
Well, I had the clerk go ahead and mark everything. Some of it is a composite. Is this it here? This first is identification, defense identification K. It's 4 pictures involving injuries to the leg.
Mr. Owens left what?
The leg.
Assuming a predicate for fair and accurate depiction, et cetera, is laid, we don't have any specific objections to K.
Okay.
Identification, defense identification, composite L, 2 photographs of a burn to her leg.
You said that was L, correct?
Yes.
Again, assuming proper testimony, that the decedent was responsible for that in a criminal manner and fair and accurate depiction, we have no specific objections at this time.
Okay.
Defense exhibit M, for identification. 2 photographs. The first one is a photograph of the back porch. Sarah's on the back porch with her 2 dogs. The next photograph is a picture of one of her dogs on one of the outdoor couches.
Okay, well,
Relevancy objection is overruled.
Identification, defense identification number N, or letter N, one photograph. It's a photograph of the living area, but also the stairs, and it shows that one of the allegations by the state is that the defendant.
Okay, no objection.
No objection to, assuming all the normal private stuff.
Judge, this is where he took a bat. It's 5 photographs where he took a bat to the TV, to Sarah's TV.
My understanding, is this O? This is still O, correct?
Yes.
My understanding from the state is there's no objection so long as the foundation's established.
Yes, sir.
Thank you.
We also intend to introduce the video. There's a short video on
It's on
Sarah's.
State's Exhibit 2, we're not objecting to that.
Okay.
As long as the foundation is good.
No objection so long as foundation is established.
P, identification, defense identification P, is 2 photographs of an incident in which
No objection, as long as foundation is laid, et cetera.
All right, no objection so long as appropriate predicate is established.
these next ones are individual photographs, not composites, but Q for identification is 1 photograph.
Part of the right stuff that we already done.
I was told this was separate from the burn. This was, I think, a slap or something, or a handle there, not the burn.
No objection to foundation laid.
With regard to Q, no objection so long as the appropriate foundation is laid.
Identification R,
No objection as long as foundation laid.
No objection to R so long as foundation is laid.
S
Same for S.
for identification,
With regard to S, no objection so long as foundation is laid.
Same for C.
T,
No objection by the state so long as appropriate foundation is laid.
Same for U.
No objection from the state so long as appropriate foundation is laid for U. Same for V.
Same for W.
W.
Same for X.
X.
Same for Y.
Y.
It's one of the other, oh, go ahead and say what
A,
it is.
identification for A,
Were these the ones that we addressed pre-trial?
yes.
Okay, thank you.
No problem with that being a demonstrative aid.
Okay.
In terms of introducing this as an exhibit into evidence,
Duplicative, competitive.
Is it contained in K through Y?
Yes.
Then, is that accurate?
I believe so. I mean, I know the clerk probably doesn't want the blow up, but
If it's
it's going to be easier to handle, the clerk to handle the
Yes.
8.5 by 11.
if it's, allow you to use it for demonstrative purposes, but I'm not going to accept it into evidence as it is duplicative of what's already in evidence as X, defense pre-marked X.
And then identification C,
Same thing, it's one of the photographs.
That was either, it was one of the earlier ones we addressed, M or N was the staircase.
And
Okay, for the same reasons, you can utilize it for demonstrative purposes, but it's duplicative as the exhibit itself will be entered into evidence. presumably.
Something like that. D, identification?
Same thing, it's one of the photographs and it's on the state's digital exhibit.
Any disagreement that it's included in your remarked?
I agree.
Okay, then same ruling. It is duplicative. You can utilize it for demonstrative purposes.
Identification E?
Same thing.
Is it included, sir, in K through Y?
Yes.
Then for the same reasons, it's duplicative. You can utilize it for demonstrative purposes only.
F for identification?
Same thing.
It's included in your submittals?
Yes.
All right, same ruling. It's duplicative. You can utilize it for demonstrative purposes, but it will not be accepted into evidence.
Identification G?
Same thing.
Is it included in your submittals, sir?
Yes, sir.
All right, for the same reasons, I find it's duplicative. You can utilize it for demonstrative purposes, but not seeking it into evidence.
H?
Same thing.
Yes.
Same ruling. You can use it for demonstrative purposes, but it will not be received into evidence by virtue of it being duplicative.
Identification I?
Same as T.
Any disagreement with that, sir?
No, sir.
All right, same ruling. Court finds it's duplicative. You can utilize it for demonstrative purposes.
Identification, Madam Clerk?
Hang on, is that the house?
It's either Delta or B.
I think that's Bravo. It's at the defendant on the porch with the two dogs?
Yes?
That was pre-marked before trial as Bravo.
And a B?
That's a B.
Same.
Same.
It was as defense M. Relevancy objection is overruled, but I'm not going to allow the enlargement as it's duplicative, as the native photo is in evidence. But you can use it for demonstrative
Yeah, I
purposes.
probably want to use these in closing and just use this, use that for the.
However you see fit, sir.
Okay, this is not working today?
I can't speak to that. I don't know that anybody today has utilized it.
I know it-
But that's not connected to the overhead. That's separate and apart from the overhead.
Okay, oh, okay. Judge, what other evidence do we have? Body cams? Excuse me? Nothing else? Nothing else through Sarah. There may be some body cam footage to refresh memories. We've got two deputies out there.
Okay. All right.
Um,
Any other exhibits with regard to Ms. Boone at this point in time, Mr. Owens?
No, sir?
State any reason why we cannot ask Ms. Owens or Mr. Owens to continue his inquiry of Ms. Boone and have her return to the witness stand. All right. Mr. Owens, anything else we need to discuss, sir?
One moment.
Sure.
Judge, I think we're ready.
Okay. If we can bring Ms. Boone back up to the witness stand. Once she is seated, we can bring back in our panel. Let's go ahead and stand and bring back in our panel.
jury entering.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
All right, thank you. All can be seated. Members of the jury, again, you could, once seated, raise your hands to confirm that you complied with the court's instructions during our last break. Record reflect all hands have been raised. Mr. Owens, you may continue with your inquiry, sir.
Thank you, Judge. Ms. Boone, so I think we left off. You had called your ex-husband?
Yes.
All right. After you called your ex-husband, what happened after that?
I ended up falling asleep.
Okay. Do you remember waking up the next morning?
Yes.
Did you sleep in?
Not intentionally.
Okay. But you didn't get up at 8 o'clock, did you?
No.
Did you wake up closer to noon?
I believe so, yes.
Did you check the time?
No.
Now, did you hear your phone ringing?
Yes, my phone was ringing.
And did you answer it right away?
No.
Do you know approximately how many times it rang before you answered it?
I believe the call was about 3 times.
Did you know who was calling?
I figured it was my ex-husband.
And why would he be calling?
To make sure that I was still on schedule to pick up our son.
At 3 that afternoon?
Correct.
And he goes to school there close by?
Yes.
All right. When you woke up, did you stay in bed for a while?
For a little while, yes.
Or tell the jury what happened when you got up.
I knew it was my ex-husband calling repeatedly. I didn't answer right away because one of our problems is that he doesn't understand that I'm doing things around the apartment and looking for jobs and so on and so forth. So I inevitably just let it ring, and I laid in the bed, and I figured that George was downstairs either drinking or looking for jobs, or may have just left. And so eventually I decided to get out of the bed and start moving to go downstairs. I was motivated enough to go downstairs, and when I went downstairs, it was very quiet. So I had the understanding, I believed that he had left. And
Did you check to see if where would he be looking for a job at?
usually on the couch, he would have my son's laptop, and he and I, which we would share.
Y'all
To
only
look for
have
jobs.
the son's laptop,
Correct.
and the TV was not working at this time?
The TV was not there.
Okay. So you thought he would be in the living room on the laptop?
Yes.
He was not there?
No.
Where else did you look for him?
I looked on the back porch. I went through the front door to see if my car was there, thinking maybe he had taken my car. I checked the bathroom, and when I was checking the bathroom, I saw the suitcase, and I remembered about the night prior, and I unzipped the suitcase
Let me
and
stop you there. You said you were in the bathroom when you saw the suitcase, or coming out of the bathroom?
No, where our bathroom is, I would have to go to the bathroom here, and then when I turned around, I noticed the suitcase, and I remembered.
How did you feel when you saw the suitcase?
I don't think I've ever experienced anything like that before.
Describe it for the jury.
I guess I was aghast, and I just can't describe the feeling.
Bless you.
Terror to
Bless you.
a certain degree.
I'm sorry, say that again now?
It was terror to a certain degree. I just can't describe it in words, the feeling of remembering. And then he was still in there.
So what did you do?
I immediately unzipped the suitcase, and I was screaming, "George, George, George," and I was shaking him, and I pulled him out, and I stretched him out flat, and then I began instantly trying to do CPR, and then was trying to look for a pulse or a breath or just anything, and was just screaming his name over and over and over again, and come on, George, and I continued CPR, and I continued CPR, and he was gurgling, and
What color was he?
what color was he?
Yes.
He was purple.
At some point, did you call your ex-husband?
Yes, when he started to gurgle, and I knew that my ex-husband is notorious for bringing my son over in very inopportune times when George is possibly drunk or doing things not appropriate for my son to see. And I just didn't know what to do. It was just a quick knee-jerk reaction. Ryan was kind of my go-to person because of my family being deceased, and I don't have anyone else that I can call. And I just wanted to ensure that he would not bring my son over in the process of all of this at some point.
So you called him.
I called him.
Did you ask him what to do? Or did you just tell him to come over?
I just told him to come over.
Did you tell him that you felt like George was dead?
Yes, I did.
And how far, you said it's 5 minutes from house to house?
Yes.
Did you call him back?
Yes, because he was taking so long. It felt seconds were hours. Yes. I'm still doing CPR at the same time in the process of it. I'm
Yeah.
doing CPR, I don't know how many times.
Did he get there?
Yes,
Did he walk in?
yes,
Did he walk out?
yes.
What did he tell you to do?
Call 911.
What did you do?
I called 911.
Is that the recording we've heard here in this trial?
Yes.
Did you love George?
To this day.
Why did you love him?
George was very passionate. George was a very real person. George was nice to me on the good days. George complimented me. George and I were two bodies with one soul, he and I would always say. I don't believe that I've ever had a connection with anyone like I have with George.
Did you have that connection with your ex-husband?
I did not,
Was it even close?
no.
George has some good traits, doesn't he?
Very much.
Did George have some bad traits?
He did.
Did you drink too much?
I did.
Did George drink too much?
Yes.
Tell the jury about George's drinking.
If George was able to, he would drink from sunup to sundown. And me having my son and trying to work and maintain the home and just have a life, a normal life as best as I could. Somehow that upset George, and because I had a certain dollar amount from my divorce settlement, at one point it was from wine we could afford vodka, so a lot of the times he would take my car and my debit card and go buy the large, we call them handles, of vodka, which is the big bottle. And sometimes he would finish that all off on his own throughout an entire period of a day into an evening. That's honestly where I thought that he was going to be that morning when I came downstairs, because he's notorious for just automatically already being outside from drinking all the time.
All right. And you said you have an alcohol problem. George has an alcohol problem.
Yes.
How did George's drinking adversely affect you?
It would debilitate my ability to help him the way that I was always trying to help him, because it would be one good day, a day of survival, and then it would be another day where I'm having to peel him off of me and call 911.
Why would he get that way? Tell us his pattern as it relates to drinking and then.
Judge, object.
Approach. Objections overruled for now.
Y'all were together 3.5 years.
Yes,
Is there times when he would get to a state of intoxication where he would get violent against you?
quite often.
Judge, can I approach the witness?
Yes, as long as you show it to the state first, please.
I'm going to show you defense exhibit for identification P. It's 2 photographs. Could you look at those photographs and see if you recognize those?
I do.
Are those 2 pictures of your body?
Yes,
Did they show injuries to your body?
yes,
Were those injuries caused by Jorge Torres?
yes,
Are those photographs a fair and accurate depiction of the injuries you sustained at the hands of Jorge Torres?
on this occurrence, yes.
Do you remember this occurrence?
I don't, it was so often.
You don't remember a specific date,
I don't,
but you're sure that that's you?
yes,
Is that the injuries that he, what's the injury to the rib cage?
I don't remember specifically. These may be the pictures. So, when we used to go over to his brother's house, one of his brothers and his,
Objection. Non-responsive.
Sustained.
You don't have to answer the question. Just, do you know what happened to, did George cause these injuries?
yes,
All right. Were y'all both drinking at that time?
I don't remember on this instance.
Judge, I'd like to move this exhibit into evidence.
Okay.
All right, what was pre-marked as P will be received into evidence without objection as Defense Exhibit 2.
I'm not sure I know how to do this.
Mr. Owens, may I get into just a number, please? Thank you.
Mr. J, would you be so kind? Thank you.
And I need to ask permission to publish it.
Yes, sir.
Mr. Henderson.
You may do so.
All right, this is night, Judge.
Looks like I think there's a wheel on the top where you can use to, there you go.
Ms. Boone, is that you?
Yes,
Are those injuries to your arm?
yes,
Were they caused by Jorge Torres?
yes,
And during the same incident, is this you?
yes,
Is that an injury or bruise to your ribcage area
yes,
and your arm?
yes,
I'll show you identification, defense identification Q. See if you recognize that photograph.
yes,
Is that your thigh?
yes,
Okay, do you remember this incident?
yes.
Can you tell the jury what happened?
I wanted to take my dogs for a walk and get off of the back porch.
Were y'all drinking?
Yes. And he was upset that I would rather go walk my dogs than sit there and continue to drink. So he slapped my thigh as hard as he possibly could and said that you're not going anywhere. And it was a good smack on my thigh.
Is that a fair and accurate depiction of the wound that you suffered as a result of Jorge Torres slapping you on the thigh?
Yes,
Judge, I'd like to offer Q in evidence.
No objection.
What was pre-marked as Q will be received into evidence without objection as defense 3.
Judge, can I publish?
You may, sir.
And for the jury's sake, is this the photograph you just mentioned?
Yes.
I'm going to show you identification, defense identification S. See if you recognize that photograph.
I do.
Is that your hand?
Yes.
Is that your blood on your hand?
Yes, it is.
Is that you standing, looks like in a room with flip-flops?
This is in the kitchen at Brian's house.
Okay, what happened there?
So George was very drunk, and I wanted to leave, and he's notorious for taking my car keys and putting them around his neck, and my phone in his crotch area, and telling me to come get them. And I really wanted to leave because of how drunk, and I knew the escalation of his anger. I didn't want to be there when it was at its peak. So I tried to take my keys from around him because he kept taunting me to take my keys, come get your keys. And so I attempted to go and get my keys. And so he ended up getting a butcher knife. And I had an opportunity to call Brian to come and help me, to please come pick me up, to come get me. And of course, he brings my son with him. And so I'm in the parking lot asking Brian to please help me get my car keys away from him, and there's neighbors, and it's a scene at this point. And George comes to the doorway of my townhome wielding the butcher knife, saying that, do I curse?
Yeah.
That no one's going to take her fucking keys, no one's gonna fucking come into this house, and he's waving the butcher knife. And I walked up to him, and I just wanted to leave, and my little son, who was, I believe, 7 or 8 at the time, just is screaming, give mommy her keys, give mommy her keys, let her leave. Brian was even trying to negotiate with him, saying, please, you know she'll come back, just let her leave. So I went up to try and take the keys from him, and he was pulling on them, and I ended up pulling harder. And he pulled them back again to try to pull me in the house, and I pulled them even harder, and it ripped my finger. And at one point, I had lost the fingernail, and the tip of my pinky was severely gashed.
Judge, I'd like to offer this for the evidence.
No objection.
What was it pre-marked as, Counselor?
Looks like S, but Madam Clerk, may have
What was pre-marked as defense S will be received into evidence without objection as defense 4.
Ms. Boone, for the jury's sake, is this the picture you were referring to? Is that the nail, or was it on, still on?
I believe so, yes.
Now I'm showing you a composite identification L, 2 photographs. Can you look at those photographs and tell the jury what they are?
I wanted to eat, and while he was drinking, went and made myself, as quickly as I possibly could, a microwave bowl of, I believe it was broccoli and cheddar soup. And I didn't get it out enough time, and he came up behind me and he slapped it out of my hand. And it was a 2nd-degree burn. I went to the hospital for it.
Are those fair and accurate depictions of the injury, of the burn to your thigh?
Yes.
We'd like to offer identification L in evidence.
No objection.
What was pre-marked as L will be received into evidence without objection as defense 5.
Permission.
Yes, sir.
had to go to the hospital as a result of these injuries to your thigh?
Yes, it was
Okay.
extremely
Is this-
painful.
Is that a depiction of the burn?
Yes.
Is that your thigh
Oh my God, yes,
and your knee?
yes.
All right, I'm showing you the composite exhibit for identification K, 4 photographs. Did you look at those, all 4, before commenting? This is a longer story, isn't it? Go ahead and tell it.
So, George stabbed me in my leg. And it was one of those where maybe if I start making dinner now, it will be over at a particular time and we can go to bed at a reasonable time. And I even put it in the bedroom and had a movie set up for us to watch. So it would just kind of be dinner in bed. And then he came upstairs and saw that I had made the steak dinner, and I don't know how to describe how drunk he was, but it definitely was not George. And had him come lay on the bed, sit on the bed, and, you know, put the, I got the dogs out, and I presented him with the steak dinner, and sat down and was getting ready to start playing the movie. And he starts being very rude and cursing the steak and finding fault with it. And then, you know, I'm having to encourage him to eat. You know, if you want me to cut it up for you, I will cut it up for you. Did you want some more sour cream for your potato? What can I do to make you happier? And then he started to pull on me and kept saying that, excuse me, that I just want to fuck you on the steak and fuck you on the potatoes. And I took offense to that, and I kept trying to encourage him to eat. I started to
Was
eat.
this just him really drunk and saying nonsense?
I don't know why he was so angry that day. I don't know if it's because I got steak. I don't know. Most of the time, I don't know the reason why. I couldn't take it anymore. Obviously, I was not going to be able to eat, so I started to crawl off of the bed to leave, just the bedroom. And he told me again that I'm not going anywhere, and he stabbed me in my leg, and it crunched. You could hear a noise that it made, and blood just started to come out of my leg, just like a fountain. So I got off of the bed. He's starting to freak out, and grabbed me a towel. I got a wet towel, and I'm sitting here holding the towel, and it's increasingly becoming even more and more saturated by the minute. It's just minutes. So I'm going through towels and towels, and I said, George, I think I need to go to the hospital. This is not stopping to bleed. This is serious. And he got on his knees and begged me, please don't call the police. Please don't call the police. Please don't call the police. And inevitably, he went and got my car keys and put them around his neck again, and my cell phone. So I was not able to call anyone, and I wasn't able to leave in my car. So I figured I would just go downstairs, and I'm just gonna go downstairs, and I had propped my foot up on the glass table that we had, and blood is just everywhere. Blood is everywhere. I can't keep up with the amount of blood, and I'm starting to feel very weak and really weird. And he comes downstairs, and he's still begging me, please don't call 911, please don't call 911. I kept telling him, there's something, this is serious, this is something. Because he knew that he would probably get arrested or something bad would happen to him. So I couldn't take him anymore. He was just all over me and just, I'm bleeding. I'm bleeding very badly, and he's having me try to console him. And I kept telling him, please, I need to call 911, please. And I said, okay, just give me a moment. And I crawled upstairs to my son's bathroom, which is the furthest bathroom away from everything. And I remember holding onto the sink. And I looked into the mirror, and my lips were blue. And I knew I needed help. I needed help. And he came upstairs looking frantic for me, calling my name. And then I turned to him and I said, please, I'm going to die. I've lost a lot of blood. There's something wrong. My lips are blue. Please, please, we don't have to call an ambulance. If you could just take me, I'll drive whatever I can do, please, to go to the hospital for this. And he said that before anything happens, I had to concoct a story in order for him to not be arrested or be in trouble when we did inevitably get to the hospital. So I'm sitting there with this blood-soaked towel with blue lips, trying to come up with a story of what I can tell them when I go down there so he's not in trouble, and telling him that it's okay. And I came up with the story of that we were sword fighting silly after drinking with our steak knives, and he accidentally punctured my leg. And from there,
How did you get to the hospital?
originally, he told me to drive, and because of the amount of alcohol that he drank, and I couldn't. So he got into the driver's seat and drove me, and the entire time he's barking at me to make sure that I get the story straight. We're sword fighting, okay? We were drunk,
Did you go to
being
the
silly.
emergency room?
Yes,
All right, and did you get treated there?
yes. I was bloody, and
All right, let me show you the photographs. Can I show you these? All right, is this a fair and accurate depiction of the injury to your leg?
yes, I had to go to 2 different hospitals for it.
And you lied to medical personnel about how this happened?
Yes, they brought in sheriffs and everything.
Was it consistent with, they brought in sheriffs? Did you have to answer to the law enforcement officers?
Yes,
Did you stick with the story that you and George had agreed?
I did.
Judge, I'd like to offer this composite exhibit.
What was pre-marked as K will be received into evidence without objection as Defendant 6. You may publish, sir.
Thank you. And is this you at the hospital?
Yes.
Is this a stab wound to your leg?
Yes.
Is this a close-up of the stab wound?
Yes.
And was that, did you hurt your foot?
No, due to the injury, I had other problems with the surgery.
Okay. But you eventually recovered?
Eventually, yes.
Do you have a scar to that effect?
I do.
Judge, can you step down and show the video?
Mr. J? You may. There's a lock, sir. Out.
All right, I don't know how best to do this, Judge, because we've got this bar.
They can probably see it from there.
Is this the injury here? Looks like there's an indentation. All right, I'm showing you identification T. You recognize that photograph?
I do. Yes.
All right. Looks like you've got an injury to your lip and to your face. Do you recall this event?
I was trying to sleep, and
Have y'all been drinking?
I'm not sure. I know that he had been drinking. This was one of the instances where I would go upstairs to try to go to sleep. And
But
he-
y'all drank together a lot, did you not?
Sometimes, yes.
But there were times where he wanted to stay up and continue to drink, and you wanted to go to bed.
Many times, yes.
You were done, he was not.
Correct.
Was that one of these times?
Yes.
So tell us what happened.
I'm sleeping in the bed, sound asleep, and he comes into the room and grabs me by my hair a lot of the times. And from here, he scratched me from trying to grab me, and then grabbed my hair and pulled me off of the bed, and then raked my face across the carpet. These are carpet burns.
To your lips?
Yes.
What about to the, looks like the eyebrow area?
That's from where he, from grabbing me, scratched me and got a hold of me by my hair.
Why was he mad at you?
Because I wasn't downstairs with him
He wanted you to be drinking with him?
all the time.
All right, I'd like to introduce identification T and evidence.
What was pre-marked as T will be received into evidence without objection as Defense Exhibit 7.
Paul, permission, Paul.
You may, sir.
All right, you see the injury between the eyes and the injury to the lip,
Yes,
as you described?
yes, and then the blood going down my eye, yes.
Showing you what has been marked state's exhibit for identification, or defense exhibit. You, for identification.
Yes,
Can you describe that photograph?
I can.
Go ahead.
This was the first time that I ever called 911. George and I had gone to a bar across the street within walking distance, and at some point, I asked a guy, or he asked me, somehow or another, it was over a cigarette. And he left, and I didn't know where he went, and the bartender said, oh, he left. He took your car and he left. So,
Why would he do that?
well, I found out when I got home, it was because I spoke to another man. And so I paid the tab and I walked home, and he's sitting on the back porch with the handle of vodka, and I was walking on eggshells and terrified and kind of treaded lightly when I came in, and he acted all natural and fine. So I didn't know the reason why that he had just gotten up and left with my car. So then he calls me a whore, and then he calls me a slut, and then he calls me a cunt, and gets up and pushes me. And he pushed me with both of his hands so hard that we have this little area where our washer and dryer is, and there are metal doors that are on it. And he pushed me into the metal door. And then I fell back, and he got his knees on top of me, on my arms here, so I was pinned down, and was starting to strangle me, and hit my head up against the metal closet over and over and over and over and over it again, and calling me a fucking whore, and you're such a slut, and fuck you, and everything. And my tongue was flopping out of my mouth, and I thought I was going to bite my tongue off, and because of the amount of noise I guess my head was making on the metal door, he slid me down and got back on me, and then started to strangle me again. And it was on, we have carpet, but it's like concrete, and I was able to get my arms out from underneath and grab his throat and get him off of me. So I got him off of me and I pushed him off, and he came up and he goes, "You fucking bitch," and he stomped my face. And the next thing I know, I woke up. I obviously
Did you get
blacked
knocked
out.
out?
I'm obviously, I guess, yes. And he was passed out on the floor. And I woke up frantic looking for my phone, and I immediately called 911.
Okay. The police arrived on that incident?
Yes, they did.
Is this a fair and accurate depiction of the injury you sustained as a result of him kicking you?
Stomping, yes.
It was a stomp?
Stomp.
With his
All I
heel?
saw was his heel.
This is, we'd ask that this be identification you be admitted today.
What was pre-marked as U will be received without objection is defense 8.
Was that the next day, or is that a few days later?
That's a couple of days later.
And that's the bruising from the kicking of the eye?
Yes.
Now, the police were called, and we're going to talk about that in a minute, but let me go through these first. I'm showing you identification V, defense. Could you recognize that? You have to speak up.
Yes.
Can you identify that picture?
Yes.
Is that your leg?
Yes.
And is that was like the injury to your knee?
Yes.
Is that a fair and accurate depiction of the injury you sustained to your knee?
Yes.
Do you remember how that happened?
Yes.
Did you tell the jury?
I was trying to get off of the back porch, and he grabbed me and pushed me, and it was a rock or a really sharp piece of mold from him grabbing me and pushing me onto the ground, and I guess I just happened to hit my knee just right on whatever it was.
Were y'all drinking?
Yes.
Why did he push you?
Because I wanted to get off of the back porch.
He wanted to stay out there?
Yes.
He wanted you to be with him? What's the deal with him wanting to be with you all the time?
Insecurity, I guess. I don't know. I don't know.
Did you do your best to please him?
And then some, yes.
All right, I'd like to introduce in evidence identification.
What was pre-marked as V will be received into evidence without objection is defense 9.
Now, Ms. Boone, were you treated for this, or did you self-treat? Let me show the jury now.
No, that was just, I got the first aid kit that I have for my son, and I just cleaned it up.
You what?
I said I got the first aid kit that I had for my son, and I just cleaned it up and put a Band-Aid on it.
All right, I'm showing you identification W. Defense identification. You recognize that photograph?
Yes.
What is that a photograph of?
This is a photograph of my arm.
And is that a fair and accurate depiction of the arm with some type of injury?
Yes.
Do you remember this event?
Multiple times, yes.
Well, I'm talking about this isolated event where this photograph was taken, the injury you sustained.
Yep.
Who injured your arm?
George Torres.
You remember this event?
Yes.
Did you tell the jury about it?
This was one of the instances where I would try to pull away from him, and I don't know how my arm started to do this, but from him pulling from this way, how hard he would pull, with me trying to struggle to get away from him, it would leave these bloody under the skin splotches.
So he wouldn't hit you sometimes, he would just grab you and pull you.
Yes, from me trying to pull away from him, that's the point of it doing this, from me pulling away from him.
Now, this is one of the many times y'all were both intoxicated.
I mean, I can't say for sure, but yes, but whenever it would happen, yes, it would be drinking.
Identification W in evidence.
What was pre-marked as W will be received into evidence without objection as Defense Exhibit 10. You may, sir.
All right, it doesn't look like a wound or anything.
Objection to commentary.
Sustained.
Tell me, I'm sorry, tell me, you said it's just from the grip, him losing his grip?
Yes, it would be from me pulling away from him, and whatever under the skin it was that it was disturbed from the amount of pressure of him holding and then pulling from me would create those on my arms.
Okay. I'm going to show you Defense Exhibit X for identification.
Yes.
And what is that a picture of?
This is a picture of my ear, side of my head.
Is that a fair and accurate depiction
Yes.
of the injury you sustained by Jorge Torres?
Yes.
Do you remember this event?
Yes.
Were you drinking?
I at the time was not drinking.
On this event, you had not consumed any alcohol.
I mean, I may have earlier. This was another, I was in the bed trying to sleep.
Where was George?
Downstairs drinking.
All right, and so you were wanting to go to bed, and he wanted you to stay down there with him?
Yes, I was in the bed.
All right, tell the jury what happened on this event.
I believe this was the instant where I was in the bed and I used to barricade the door with our dresser.
Why didn't you just lock it?
All of the locks were broken in my home.
Why?
They were from George taking them in, including my son's. At one point, I could seek refuge in my son's room, but he broke that one as well.
Well, tell me, explain how that happens. Tell the jury. We can't read your mind.
George wants me, which he has told me numerous times, that I am to be with him at all times and doesn't like to be apart from me or away from me. So whenever it was, even just to go to the bathroom sometimes, he would go with me. And you have to understand, I have a 2-story, 900 square foot townhome, so there's not many places to go. So it just happened to be that it would be upstairs or downstairs, or I'd be in a particular room or not. So inevitably.
Did you want some time away?
Yes, I did. Even if it were just him upstairs or me downstairs or vice versa. So I rarely got to sleep. This was one of the instances because I had barricaded the door with our, 200-pound dresser that we had. And then I had my nightstand barricaded up against the bed, to where it was even more difficult from the prior times of him breaking in. And he would, I don't know how he would ever do it, but he would get himself in through the crack of the door that he would be able to wedge the dresser in the nightstand. And he pulled me out of the bed and told me I was going to die. And I believe it's this incident, and then punched me, and
Punched you in the side of the head?
yes, in
Was
my
it a-
temple and everything.
Was it an open fist or a closed fist, or do you know?
It was fully closed.
Like identification X introduced in the evidence?
What was pre-marked as X will be received without objection as Defense Exhibit 11.
All right, I'm showing you this exhibit. That's you? Did you get any treatment for that? Medical treatment?
I know the police came, but I don't remember. I remember it hurt for a good solid 2 weeks after that.
Was this one of the incidents where the police were called?
Yes.
recognize this photograph, which is identification Y?
Yes.
Was that the date of the incident? The date of this event?
No, it happened prior. I mean, but this picture that was taken of the,
This picture was taken, would have been taken February 24th of 2020?
yes,
And do you recognize that as your close-up facial?
yes,
Is that a fair and accurate depiction of how your face looked on February 23rd of 2020?
yes.
What's the significance of this picture?
Again, because I was sleeping, George was upset with me and came in with a metal curtain rod and bent it and snapped it in half and then crunched me in the forehead with it. And it started to beat the furniture that was in the bedroom. This is probably a good month before or after it had happened, before I really do believe that I should have gotten stitches, but I was not allowed to go to the hospital.
Judge, I'd like identification Y introduced into evidence.
It was a gash.
What was pre-marked as Y will be received into evidence without objection as defense 12.
Is that the same curtain rod that you mentioned in the 2-hour interrogation video?
Which they didn't take, yes.
This was photographs that were taken, I guess it would have been the crime scene? Was it the crime scene investigator that came out and took photographs?
I don't remember who it was, but yes, someone did on the day of the incident.
Was it different from the extraction, the phone extraction expert? Was it somebody different?
I think.
But is it this wound right here?
Yes. And remember, that's a month later.
And then on that same date, they took, same time, they took this photograph as well, which is identification R.
Yes.
All right, and what does that do?
I believe it's from holding the baseball bat, and
Is that an injury to your hand?
it's a bruise.
Was that taken, was it February 23rd, 2020, when the investigators came out, when,
February 24th, I believe.
February 24th? Okay. I'd like to introduce identification R to the evidence.
What was pre-marked as defense R will be received into evidence without objection as defense 13.
Judge, you can publish.
Yes, sir.
All right, this is not a great photograph, copy of the copy. But February 24th of 2020, is that what you were wearing? Is that you?
Yes.
Okay. And there's some discoloration up here of your palm. You see that?
I do.
Is that from you jabbing him with a baseball bat?
Sustained.
Do you know how you suffered that injury?
I believe it's from holding the baseball bat.
When you poked him with it?
Yes, trying to get his hand back in.
I'm showing you defense identification N. Just like 5 photographs. Can you look at those? See if you recognize them.
Yes.
And are those fair and accurate depictions
Yes.
as a composite of the events that occurred in relation to George Torres and your TV?
Yes. Yes.
All right, are those stills of a videotape that you took?
Yes.
And is that videotape, was it on your phone?
Yes.
So when law enforcement sees the phone, they would have had access to this video?
I believe so, yes.
And tell me about it.
Lucas liked to watch cartoons and play video games on the big screen, this is the big screen, and I would have to call Brian to come over sometimes to help me figure out the Fire Stick and whatever platform or whatever it was that Lucas was trying to view his shows and video games on. And I don't remember how George found out that Brian had come over. I believe because it was actually fixed and he knew that I didn't know how to do it. Found out that Brian had come over to fix it, and
Was he jealous of Brian?
I don't know if he was jealous of Brian. I think that he had a fear that I somehow would go back to Brian. So I think by Brian helping me with things for Lucas, he just didn't want him to be interacting with me at all.
So Lucas wasn't over here this day, was he?
No.
Brian wasn't over here this day.
He may have been, I can't remember when he actually fixed the television for Lucas.
But y'all were drinking this day.
I know he was for a fact, yes.
Chances are you were.
Probably so, yes.
Okay.
I would agree.
So how did it end up badly?
He accused me of sucking Brian's dick and told me that he was going to break my face with the bat, and that he was going to make me unrecognizable to my son with the bat. And then told me that he's going to destroy my fucking television, and then I was going to remove it from the apartment. And if I didn't, I was going to be, again, unrecognizable to my son.
So did he grab the bat?
Absolutely, he already had that in his hand, and he told me that I had to videotape it.
Did you videotape it voluntarily?
No.
All right, but there is a video, but I'm gonna go ahead and ask Judge if I could introduce this identification of these 5 photographs into evidence.
Objection.
Is it O or N?
I have O being a composite with 5 photos, and I have a single photo.
We're moving in O, okay. All right, what was pre-marked as O will be received into evidence without objection as defense 14.
All right, so these are some stills from the video. This was George, that particular day, holding the bat.
You guys telling me that I'm going to take the television out once he destroys it.
He wanted you to take the television out?
That, or I was going to help him, but either way, I was taking it apart and removing it.
And what is this picture of?
In the process of him destroying my television.
While you're videotaping?
Correct.
Is that the result?
No. After that, he ripped it off of the TV stand.
Did he later pass out?
Yep, like he usually does.
What's he drinking then?
I don't know. Vodka and something, I'm sure.
showing you identification N. See if you recognize that.
It's my living room in the stairwell.
All right, were those, was that a photograph taken by a crime scene?
Correct.
Is that a fair and accurate depiction of your living room and stairwell?
Yes.
And I'm going to try to introduce this as identification 9 as an exhibit.
No. It's pre-marked as M, correct?
It's got N.
N, I apologize. What was pre-marked as N will be received into evidence without objection as Defendant's 15.
Can you tell us a little bit about this room?
This is my living room. This wall that we have over here with the hearts, that's where we would display all of our artwork. We were in the process of taking it down to add more, so he could continue to be entertained. The bookshelf over here is my son's bookshelf with all of his toys and little guns and musical instruments. He's got his little karaoke machine down here, his guitar. The stand right here with the red bucket on it, that was the television stand. And then my back porch area and the dog bed here.
And then it looks like in front of the bookshelf at the foot of the stairs is that a doggy?
It's a baby gate, but my dogs would wander upstairs sometimes and go to the bathroom sometimes when we couldn't get them out. So I would, at nighttime, or whenever we weren't home, make sure that they didn't go upstairs. And plus Penny was blind.
There's an allegation that you pushed George down the stairs
Apparently,
or got him in the suitcase upstairs and pushed him down the stairs?
supposedly,
Did that occur?
absolutely not.
Is that bookshelf disturbed in any way?
No, nor the plant next to it.
I'm showing you composite, 2 photographs, identification M. Did you look at those 2 and see if you recognize them?
Yes, this is me sitting on the back porch with my dogs. And as you can see that we are both drinking.
All right, who's taking the picture?
I'm guessing George's, or maybe it's one that Lucas, Lucas wasn't over here, so it had to be George.
How can you tell y'all are drinking?
Because there's a cup here and then he has a beer.
All right. And there's 2 dogs, there's one sitting next to you. Who's that?
That's Penny, she's the blind dog. I used to have to pick her up to put her somewhere so she would stay there because she was unfamiliar with the area, especially since we moved from my marital home to the townhome. So most of the time Penny would be close or next to me.
Who's next to the film?
This is little guard dog Tess. She was the deaf dog. And this is the fence here.
Well, I'll show them.
Okay, but this is Tess, and then this is deaf, blind. Penny and Tess.
All right, and then the second one.
This is Tess on the back porch, taking a nap. She was never far from me.
All right, when George was sober, how did he treat the dogs?
Nice. I don't know if he was a pet person, but I mean, he was nice. If I needed him to feed them, he would feed them.
Were there times when George was drinking where he would threaten to harm the dogs?
All the time.
All right, you're going to have to tell the jury specifically.
One of the worst threats was Penny being blind. He would actually leave the gate open in the back. He wouldn't threaten me to do it. He would actually do it on nights that I had to go up to sleep or I fled the night before or something. and would tell me that he hoped that I would come back and find her bloated body dead in the pond across the way from our townhome. And Tess was notorious if I wasn't there to go look for me, and would say that he would hope that I would have to scrape up her dead body from the street that was out in front of our apartment complex.
Why was George upset with you? Why would he threaten to harm the dog?
Anything that he could get to try to have some type of hold over me.
Control?
And he knew I loved my dogs very much, especially that they were handicapped.
Were they afraid of him?
Yes. Penny would hear his voice and instantly go underneath the dining room table that we had. Tess was always fractious and very, very quick with his movements, but she was never far away. They never showed their teeth, they never growled. Tess would occasionally bark, but it was very rare. And he used to kick them and just,
For what reason would he kick them?
Penny would try to find me because she's blind.
Speculating in the mind of the dog.
Sustained.
I'd like to move identification M and evidence.
Any objection? Was pre-marked as M will be received into evidence without objection as defense 16.
All right. Can you describe this for the jury?
This is again is our back porch, and this is the fence that I made for the dogs to have a little bit extra space. Penny is next to me. She's the line dog, and then Tess is down here at guarding the gate.
Are these fake rabbits? Is that
Yes.
here?
I used to call my son when he was a baby. He was my bunny rabbit.
Overruled.
He was my bunny rabbit, so I used to collect bunny rabbits, and so I have rabbits here and there throughout my house and in my little garden area.
All right, this is the alcohol you are consuming,
Yes.
and this is a close-up of which one?
This is Tess. She's the deaf dog.
How old were these dogs at that time, 2020?
Gosh, maybe 9, maybe 10.
We approach.
Yes. All right, members of the jury, it's 4:03. By show of hands, would you like to take an afternoon break at this point in time? Okay, court sees no hands. We may have to work also a little bit past 5 o'clock, maybe going to between 5:45 and 6 this evening. I know juror third from the right, you may have to make a phone call as to that. Does anyone have any concerns about working a little bit later today till 6 o'clock? If you have those concerns, please raise your hand at this time. All right, court sees no hands. Ma'am, are you in a position to step out to see if you can get assistance with childcare, or is that not an option for today?
I'm at actually all set for today. She's already taken them off.
You are? Okay, all right, excellent, very good. Thank you very much. I appreciate you all. With that, Mr. Owens, you may continue.
Judge?
Yes, sir.
Judge, I think one of the jurors raised their hand.
Oh, I'm sorry. Yes, juror fifth from the right.
Are we going to get a break before the 5:45 mark? Because if not, then yes, I would like a break now.
Then I tell you what, let's go ahead and take it at this time. We'll give you all a 15-minute recess. It's 4:04. Hang on, don't leave yet. I got to tell you a couple things. It's 4:04. I'll see you back here at 4:20. Same instruction as before. Please don't conduct any independent investigation or research as the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else. We'll see you in a couple minutes. Thank you very much.
Jury exiting.
Y'all can be seated. Thank you. If Ms. Boone needs to use the facilities, we might as well take advantage of that at this time. All right, court will be in recess till 4:20. Thank you. All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Ketchner on behalf of the state.
William J. for the state.
Defense.
James Owens from the school.
Tommy Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right. Ms. Boone, let's go ahead and bring you back up to the witness stand, please.
Judge, we're going to try to go with 6 today.
Yes, sir, that's the plan.
As much as it takes, I mean, it's nothing how it goes. You said about 20.
All right, we're ready to bring back in our jury.
Yes?
All right, let's do it.
Judge,
Hold on.
oh, she's up there, I'm sorry, I thought we lost.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, y'all can be seated. Thank you. Again, members of the jury, if you could. Oh, wait. Okay. Can the parties approach for a moment? All right, members of the jury, again, if you could just raise your hands to confirm that you complied with the court's instructions during the last break. Record reflect all hands have been raised. All right, with that, Mr. Owens, you may continue your inquiry, sir.
Just based on the court statements, identification A, I'd like to, this is one of the photographs that we introduced. Is this the injury to your ear?
Yes.
And then this is your living room, this is identification C, the blow up.
Yes.
Identification D. TV. Identification E. Is that your arm?
Yes.
Identification F. Is that your knife wound? Identification G. Is this the curtain rod?
Yes.
Identification H. This is the eye. identification. All right. See your face shot,
Yes.
with the lip, and the eyebrow. Identification B, and this is the back patio with the dogs.
Yes.
Okay, I'm gonna bounce a little bit, Ms. Boone. Let me go back to the night earlier in the evening when I think y'all may have been out on the back patio and you had suggested to George to call the children, but then I think, did he call his brother or his brother called George? Do you remember?
George called his brother.
Okay. And you made a statement about tell him something. Explain that to the jury.
I told him to tell his brother about you choking me the other day. This is a separate choking incident. We had been drinking, and I wanted George to tell him, but he didn't tell him, so I said it in the background, so he would be aware.
What did you tell him?
Tell him why you choked me, or that you choked me.
Okay. Now, you heard the testimony of the two neighbors, the boys that lived next to you,
Yes,
and you heard that they were actually questioned. I think the audio, they were audio interviewed. You heard from Detective Copsel. I think it was a couple of days later on the 25th of February, or 27th of February.
yes,
And you heard their testimony earlier this week,
yes,
where they hear a kind of a thumping sound starting at the top of the steps, ending at the bottom.
yes,
Have they got the night wrong?
yes.
Explain to the jury that.
So it was the night before. Again, I was sleeping, and in the middle of the night with the door barricaded, he came in and ripped me out of the bed. And first got me with one hand, and then got both hands and pulled me completely off of the bed. And then, like a caveman, had my hair like this and was going down the stairwell, taking me with him to come downstairs so I could sit and drink with him.
Do you believe that's the noise that the two neighbor boys heard,
I absolutely do.
and it was just the night before?
Correct.
Now, some of the time when this abuse occurred, you called the police,
Yes,
and other times the police were not called.
correct.
I want to refer to you the first time, I believe, you mentioned the 911 call. I believe that was July 25th of 2018.
Yes,
And that was the incident in which George had kicked you in the eye,
stomped me, yes.
stomped you in the eye. And you had grabbed his neck
Yes, I was able to get my arms out from him pinning me down with his knees and grab his neck.
So law enforcement came and investigated,
Yes,
and both of you were arrested.
correct.
Do you recall asking the officer when you were arrested, why am I being arrested?
Many times, yes.
Do you recall asking the officer, why am I being arrested?
Yes.
And do you recall making any other statements to law enforcement as to why you did what you did to George?
That was the first time ever that I actually officially fought back.
Did you tell the officer that you were fighting back?
Yes, because I was complete shocked that I was getting arrested because of it.
Now, on the 2-minute video, the Suitcase video, you mentioned to him, I think you said something, I can't breathe. He said, I can't breathe, and you said, that's how I feel when you're choking me. Were you referring to an isolated incident of the night before, 2 nights before, or whatever, or were you referring to in general?
In general, the more than 2 or 3, 4 times that he had done it.
Okay. And then the point about cheating, he didn't physically cheat on you.
No, he did not.
Okay. And just, I don't want to go into a lot of detail, but what are you referring to there?
George was, I believe, addicted to pornography, and a lot of that would be found on my phone from him supposedly wanting to call up job interviews. And as a solution, I sat him down and I explained to him, to me, that's you visualizing yourself with someone else, or at least having a pleasurable moment with someone else or watching other people. And to me, I told him that I considered that cheating on me.
Okay. And so he would download that on your phone?
Yes.
Why did you stay with him?
As
You got to tell the jury.
As anyone who has ever been in love, or when you love someone, or primarily someone or something, you go above and beyond, and you tolerate, and you endure, and you persevere, and you try to make that person as spectacular as you possibly can, no matter the sacrifice that you may have to go through. To serve someone else in a positive light so they can be better people for themselves, and to just make them a happier person. And love is very strong, and love is very deep, and love, I believe, is not fully understood in a lot of ways for how different people react to it. And I very much, deeply, and passionately love George. I love him to this day.
Did you not want to be alone?
Beginning through my divorce, it was very nice to have him around, and he was a man to me. And I felt protected, and he was very nice, and as lame as it sounds, he used to compliment me, and it made my day. So, yes.
During that period of time, when you first started seeing George, would it be fair to say that you had low self-esteem?
Yes.
Now, we talked about this previous arrest where you told the officer you were fighting back and you got arrested. Now, I want to talk about your conversations with law enforcement, but first I want to ask you, why did you go to the police station that day when you were interrogated there? We saw the 2-hour video. Tell the jury.
The day of the incident, the detective Copsell gave me her business card with her personal cell phone number on it and said if I happened to remember anything or anything that I would like to add to the day for me to not hesitate to give her a call. So throughout the rest of the evening, something was off. I didn't feel comfortable with what she told me and how she told it to me.
How long were you at the scene?
Gosh, all day, from the moment that they were there to the moment that the coroner's van drove off.
All right, when it ended, did you stay in your home?
No, I raced inside and collected some pajamas and a toothbrush, and I went over to where my son was at my ex-husband's house.
Did you break the dogs?
I didn't even feed them, it was so fast.
All right, and then once you got over to your ex-husband's, what happened? As it relates to Detective Copsell.
Something just wasn't sitting right with me, and I had a suspicion that she just wasn't being honest with me, so I took it upon myself.
Sustained.
So you called her. Tell us about that.
I called her and I told her that I felt that she was being dishonest with me. She originally had told me that due to her being pregnant, it would just be a lot easier for her to have me come down to the station to pick up my phone. The original plan was for she and Detective Loman to return the phone to my apartment. But she said that it would be a lot easier for me to just come down and pick it up because I remember when I was pregnant. That's what she said. You remember when you were pregnant. So I said, I feel that you're tricking me, and I feel that you're being very sneaky about something, and I don't believe that you're being honest with me. And I said, regardless, I'm still going to come.
Sustained.
So you agreed to come, but you understood it was to get your phone?
Correct.
All right, you came that afternoon to the station,
I did.
and the original agreement was they were to come to you.
Correct.
All right. When you got to the station, what happened?
I thought I was just going to be picking up my phone. My car was there. I had everything in my car. It was just a regular, I'm just going to go in, maybe sign something and pick up my phone. And there's people that are over here at the windows, and I thought that I was supposed to go over there to get my phone. And Detective Lowen came down and said that my phone was upstairs. So if I would just follow him upstairs, that's where my phone was. And then I was taken into I guess it was an interrogation room, and they told me to sit down, and that then I guess the interview or interrogation began, and I just simply was getting my phone.
Sarah, tell the jury why.
Yes. You may proceed.
Ms. Boone? Ms. Boone? Tell the jury why you lied to the police.
I lied to the police, basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made the decision to lie.
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
Now, let me take you back to this incident. Is it fair to say that when George Torres is sober, he commits no violence against you?
No.
Is that fair to say?
Yes.
Is it fair to say that every time that he's intoxicated, or every time that you're hit by him or harmed by him, it's when he's intoxicated?
Yes.
As a result, when he's drinking, does it change your outlook?
Yes.
Could you explain that to the jury?
I'm always fearful, paranoia.
Why?
Because I try to protect and defend myself for fear something happens at the last ultimate second.
But you're always that way, fearful. Is it because of these prior incidences?
Absolutely.
Do you try to placate him?
All the time.
What do you mean?
With the puzzles and the painting and feeding the ducks across the way at the pond, listening to music, trying to go for a walk on the trail, anything that I possibly can. I told you I was running out of things to entertain him with.
Why do you think George, what bothers him?
Objection, false or speculation.
Sustained.
Does he tell you?
Objection, calls for hearsay.
Sustained.
As a result of how he behaves towards you in that intoxicated state, how were you feeling the night of this event?
Objection, has to be answered.
Overruled.
Extremely nervous, anxiety galore, just, I can never relax.
When he's drinking?
Yes.
And the state of intoxication that he was at the time of this event, is that the state that scares you the most?
It's the tone, yes. There's a lot of alarms and red flags that go on throughout the day or night or whenever it is that we are drinking.
Objection, non-responsive.
Sustained.
Tell us about that. How that does that heighten your sense of safety,
At all times.
but especially when he's drinking?
Oh, yes, all the time.
And then his mood?
Yes, it depends on what mood he's in that day.
Well, do you have like a sixth sense of how he's doing?
Yes, I knew George very well.
Objection, non-responsive. Yes or no?
Sustained.
Can you tell us what you mean by that? Sixth sense, or knew him very well?
I guess you can say that I was trained by fear with him. Just, it wasn't fun anymore when we would drink and we would hang out on the back porch. It wasn't fun anymore because I knew inevitably that something was going to happen to me, one way or another.
Ms. Boone, you know, those bruises that we saw of him, they look pretty deep. Tell the jury what you were thinking.
From the bat, you're
Yes.
I didn't want to die that night. I can't describe it to you. It's terrifying love to a certain degree, where my plan was to show him the next day, and just, I wanted him to be better and treat me nicer and be the person that he was when I originally met him, and I knew that was in him still. I knew that it could be found, and I just couldn't figure out what it was that I was doing wrong in order for it to not be back to where that was. And I was tired of living in fear and just sick all the time of figuring out how I can entertain him so I don't die, and continue a relationship with my son and try to live a normal life. That wasn't a normal life for me. And just, bottom line is I didn't want to die. I would have died, or I would have been disfigured or maimed, or if it weren't me with the bat, it would have been him, if he were to have gotten out.
That's all.
Any cross-examination?
Did George know somebody named Crystal? Did you ever mention Crystal in your text messages about being one of his bitches?
I don't know. I don't remember.
How about Christine? Did George know a Christine?
I don't know.
How about a Pamela Erickson?
These may have been people that he was communicating with on whatever the platform was.
On your phone?
I believe so, yes.
And did you find these communications?
I believe I found one or two of them from some of them.
And did you send a long letter to his family to relay to him about George and his girls that he was cheating on you with?
I believe so.
Okay, so you do know those names, right?
I don't remember them. It's been however long.
Okay. Now, on February 24th, 2020, you called 911 at about 1 p.m., correct?
Yes.
And at that point, you were still feeling a little intoxicated, were you not?
It was more shock, but yes.
So you agree that you previously stated, I was still, I believe, intoxicated to a degree?
To a degree, yes.
So 1 p.m., it's about 14 hours after 11 p.m. the night before, correct?
I'm guessing so.
Well, 12 hours prior would be 1 a.m., and then 12 a.m. is 13 hours, 11 p.m. is 14 hours, correct?
Okay.
And you were present here for the medical examiner, Dr. Zadovich, to testify, correct?
Yes.
And you heard her talk about all the effects of ethanol that has on the human body, correct?
Yes.
And she also mentioned something that it, on average, dissipates at about 0.015 an hour. Do you recall that?
I believe so.
Okay. So, would it be fair to say that if you're still feeling the effects of the alcohol at 1 p.m., so that's 14 hours, 0.015, you were at approximately about a 0.21 at 11 p.m. the night before. Do you feel like you were 2.5 times the legal limit at that time?
I don't know how you came to that number.
Judge, I'm going to object.
Roach. You may proceed.
So you testified earlier that you all had about half of one of these bottles left from the night before, correct?
Yes.
And so would you agree that this is one of the 3 bottles that was purchased between February 22nd and the 2 that were purchased on February 23rd of 2020?
I'm guessing
Okay.
it's like the bottle, yes.
All right, and it's 1.5 liters, would you agree? And when you say half, are we talking about to the top of the label was left from the day before?
Oh, goodness, no.
All right, a little less, halfway through the label?
It was right about.
Okay, about halfway through the label. So in addition to halfway through the label, which you began consuming after going to Publix at about 12:15, correct? So you all would have began consuming around 12:30, is it fair to say, when you got back?
I can't tell exactly.
Okay. And after finishing what you all had left over from Saturday, the 2 of you consumed 2 1.5-liter bottles, correct?
I'm not sure about the second bottle that he purchased, if it was empty or not at the time.
Well, you did mention that the police would find 2 empty bottles in the top of your trash, correct?
Yes.
And we did all see that in the photographs, correct?
See that they
Two.
were empty in the garbage, yes.
All right, and you say you were about 100 pounds at the time?
Yes.
And we all know Mr. Torres was 103 pounds at the time of his death, correct?
That's what they said.
All right, so that's 3 liters of wine between 200 pounds split between 2 people over the course of a day, correct?
Yes.
And you testified today that you were intoxicated at the time that this occurred, the videos between 11 and 11:30 at night, correct?
Yes, at some level, yes.
Now, what does that mean to you? Previously, have you indicated that that means the room is spinning? Do you ever recall saying that?
I do.
So what was your level of intoxication at this point in time when the first video was filmed at 11:12 p.m.?
Do you mean from lack of sleep or alcohol?
From the alcohol.
What was my level?
What were you feeling? Did you have trouble with your balance?
I was more tired than anything.
Did you have trouble with your balance?
I don't believe so.
So you were able to flip a suitcase over with a 100-pound man in it, right?
I mean, yes, it happened,
Okay. How about your speech? Do you feel like your speech was slurred?
clearly.
How about your inhibitions? Do you feel like you were doing things that you wouldn't do when you were sober?
I wasn't thinking about that.
Well, on reflection, do you feel like this is something you would have done when you were sober?
I didn't know me and George.
I'm just asking you, looking back on this, when he's in the suitcase and you're telling him how you feel, and then you wait 11 minutes and you film another 22 seconds, and then you go upstairs, upon reflection, is that something you would have done and left him in there had you not been drinking?
I don't know. I can't say.
Okay.
If I was scared, then it would be something.
Okay. All right, now, today you testified about the time frame between the 2 videos, correct?
Yes?
So you came down from the shower where you were hiding, correct?
Yes?
And as you're coming down the stairs, before you even get to the bottom of the stairs, you can kind of see over your shoulder or towards your right that he's trying to hide in the suitcase, correct? And the lid is down, but it's not closed, and you can tell he's hiding in there. It's not a great hiding spot just yet, right?
Correct.
And so you come over to him, and you're laughing, right?
Yes.
And you move the suitcase around some before zipping it shut, right?
No.
No? You immediately zip it shut?
Yes.
Okay. And you're both still laughing about it, correct?
Correct.
All right. And then it's during this course of time, how quickly is it after you zip it shut that you begin filming the first video?
I don't know without watching it. I don't know.
Okay, I mean, the video's not gonna catch you zipping him up because you're like 10 feet away, right? How quickly after you zip him up is it before the video starts, is my question.
I don't know.
Okay. And then during that 9 minutes and 14 seconds is when he begins to get angry, correct?
What 9 minutes?
Between the two videos, there's 9 minutes and 14 seconds between the end of 1061 and the beginning of 1062 and 1063. So you got the 2 minute, 3 second video that starts at 11:12:45, correct?
I guess.
Permission to use state 17?
You may. All right, so we're looking at entry 31107. That indicates, according to the phone extraction, 2/23/2020, 11:12:45 p.m. Image underscore 1062 movie begins being captured. And we have seen that that is about 2 minutes and 3 seconds. Entry 31113 indicates that image underscore 1063.move disconnected. Okay. 31113, a second movie is captured at 11:23:03 p.m. Your testimony was that after that first video was captured by your phone and you, Mr. Torres began getting angry and trying to push his way out, correct?
Say it one more time, please.
Between these two movies, of which there's about 9 minutes and 14 seconds, Mr. Torres begins to get angry and try and push his way out and get out of the suitcase, correct?
He had been angry on and off throughout the entire day.
Okay. You didn't tell us that earlier. You said it was a wonderful, fun day all day, correct?
That's because I lived.
Okay. But you did not tell us earlier today that he had been angry throughout the day.
When would I say that?
You described your entire day of doing puzzles and arts and crafts and outside by the dartboard, and you said it was a wonderful day and everything was fun until he was in the suitcase. Did you not testify to that earlier today?
I did.
Okay. My specific question between these two movies is, this is when he begins to get angry and trying to push his way out and to get out of the suitcase, correct?
Angry again, yes.
And he was expressing his anger in what manner? How did he say this?
At which point throughout the day?
Ma'am, you know very well that I'm talking about between these movies. Please answer my question. Between these two movies, how did he express his anger with you?
Told me that I was going to fucking die.
Okay. Now this is happening after he's already told you several times he cannot breathe in the suitcase, correct?
Correct.
And he's been in there for whatever brief amount of time it took you to zip him up, and the laughter stops, and then you go over and begin to film, correct?
Yes.
And you're filming, your purpose of filming is to kind of teach him a lesson. This is your chance to say something to him when he can't say anything back to you, correct?
No.
Then correct me.
There was no lesson to be learned. It was just I wanted him to try to understand how I felt so maybe he could progress in being a better person the next day.
So you wanted him to understand how you felt in the past, and that's not teaching a lesson?
I just wanted him to understand.
Okay. All right, and so immediately prior to zipping him up and putting him into the movie, you had been upstairs, correct?
I'm sorry?
Immediately before coming down and zipping him up and then filming the first of the two movies, you had been upstairs in the shower, correct?
Yes.
I'm going to publish what has been labeled as image_1061, which according to the timeline was captured at 11:03 p.m. 31 seconds with her device. All right. Does this appear to be the suitcase that's in question in the two movies that are filmed at 11:12 and 11:23 p.m.? Oh. This is image 1061 taken at 11:03 p.m. 31 seconds. Does this appear to be the blue suitcase that's in the two videos that were captured at 11:12 and 11:23 p.m.?
Correct.
Did you take this image at 11:03 p.m.?
I don't remember if I did or not.
And again, we had, and by we I mean you and Mr. Torres, two 1.5 liters bottles of wine and plus whatever was left over from the day before, correct?
Correct.
So you don't remember taking this photograph?
I don't.
Do you remember whether or not Mr. Torres was in here?
I don't remember taking the photo.
Okay. So, what is your memory of what happens between 11:03 p.m. and 31 seconds when that image is captured, and then when the movie starts at 11:12:45? What do you remember?
I don't.
Okay. Do you remember anything from that night?
I do.
You told the police on February 25th, 2020, when they first showed you the video, that you didn't remember taking that. Do you remember that?
I do.
And your testimony is you do remember taking that video.
I do.
but you don't remember taking that photograph 9 minutes prior.
Correct.
Is there something, did you have more to drink in those 9 minutes?
I did not.
Was Mr. Torres in that suitcase the entire time between 11:03 when that image was taken and then when the second video was taken at 11:23 p.m.?
I believe so, yes.
So for 20 minutes? Yes?
However long the time frame is.
Did he begin telling you that he couldn't breathe before the video, or do you not remember?
I don't remember.
Now, you testified moments ago that your two neighbors must have misremembered which night the loud noise was, correct?
Yes.
And now you're telling us that you don't remember taking the photograph at 11:03 p.m., correct?
Correct.
Did the police come out to your townhouse on Sunday, February 23rd, 2020?
Yes.
I'm talking about Sunday. This is the Sunday fun day when we're going to Publix twice. Were the police out of your residence?
No.
It was the day after, Monday the 24th, correct?
Yes.
And that Monday morning, you called 911, well, Monday afternoon at about 1 p.m., correct?
Yes.
And between that time frame, you were the only person in your apartment plus Mr. Torres in the suitcase, correct?
Yes.
So if anything had been disturbed in your apartment, you had all the time that you wanted to undisturb them before calling 911, correct?
If I wanted to.
Okay. And you still, your testimony is there was no loud boom that shook the walls of your townhouse at about 11 p.m. the night of February 23rd, 2020, correct?
Correct.
To the best of your memory, correct?
Correct.
Now, that second video is 22 seconds where you just hear him say Sarah and you don't say anything, or you're familiar with that video, correct?
Yes.
It's after that that you go upstairs, correct?
Yes.
How quickly is it that you go upstairs after that?
It was pretty quick.
Can you grab the dogs?
No, the dogs were upstairs already.
Okay. Did you call 911 and let the police know that you had zipped somebody shut in a suitcase and they had not been able to get out for 20 minutes?
I did not.
Did you go to Brian's house and tell him, I had to zip Mr. Torres up in a suitcase shut? We need to do something about that before he passes.
I believe that's what the phone call was.
Okay. Well, what do you remember now about the phone call with Brian?
I know that I called him. I don't know specifically what it was about.
Now, your testimony, it seems like you spend day after day finding things to entertain Mr. Torres to do, correct?
Yes.
Almost like having a child. You have your own child, correct?
I do.
What you described sounded like having a small child, would you agree?
That's your interpretation.
Okay. Well, you take him from doing arts and crafts to doing puzzles, so on and so forth, correct?
When he's been drinking, yes.
And Mr. Torres was notorious for doing some of these things, correct?
What do you mean?
Well, you described Mr. Torres as being notoriously known for doing things. You described your ex-husband, Brian Boone, notorious for doing things like nagging and calling all the time. You remember your testimony calling people notorious for doing things?
Yes.
What would you say people would say you're notorious for?
I don't know.
And you would not answer Brian Boone, your ex-husband's phone calls just so that you could let him know that you're busy and you have things going on, correct?
I knew that at whatever time it was that he was calling me, that he could wait for the few moments of me getting up to where Lucas gets out of school at 3 o'clock.
Okay. But you wouldn't return his call, you would let him call several times, correct?
That day, yes.
Okay. How about other days? Would he have to call to remind you to get Lucas on other days?
He wasn't reminding me, he was just making sure that Lucas was covered for pickup or drop-off.
All right. You didn't mention to the sheriff's office on either February 24th or February 25th about going to Publix with Mr. Torres at noon or 12:17, did you?
I don't recall.
So the best evidence of that would be the recording of those interviews?
Correct.
Did you not remember going to Publix with Mr. Torres that day?
At what point?
At any point?
No, I didn't.
You had indicated to the police that it was about 4 p.m. that you all had started drinking after doing chores. Do you recall that?
I do.
And your testimony today was that it was really more after you guys went to Publix at about 12:17 p.m., correct?
Yes.
And you did not tell the truth to the police, correct?
I'm sorry, I didn't hear the question.
You did not tell the truth to the police about that, correct?
I did not.
And when they were asking you about Mr. Torres's injuries, you told them that you had nothing to do with it, correct?
Yes.
And that was not the truth.
Correct.
What did you all have for breakfast on the 23rd?
I don't remember.
Did you all have lunch?
I believe we had leftovers from, I think, something that we had in the fridge.
And do you recall what those were?
Not at this point, no.
And then I believe you mentioned having a sandwich of some sort for dinner?
No, I believe it was for, I'm guessing he and I ate at the same time.
And at one point, Mr. Torres called his brother Juan, correct?
Yes.
And do you admit that you were yelling in the background, telling Mr. Torres to tell his brother that he had been choking you?
I don't know if I was yelling. I know that he could hear me through the phone.
Okay. So how long had that been going on that day? When did you start getting on Mr. Torres about choking you in the past?
He and I had conversations about it because he didn't remember doing it to me. And the next day and the day of,
Is it fair to say that there are just points in time where you don't remember what you do either, correct?
are you talking about almost 5 years ago?
I'm talking about from drinking. Is it fair to say that you don't often remember things that you did while you were drinking?
I would not say often.
Okay. In the course of your relationship with Mr. Torres, are there things you don't remember happening that happened the night before between you and him?
I can't say that at this point.
But you said that you don't remember taking that photograph at 11:03 p.m. on February 23rd, correct?
Yes.
Was there anything else that you were telling Mr. Torres that he needed to tell his brother?
Not that I can recall.
Was there anything you were telling him that he needed to tell his daughters?
Not that I can recall.
Now, you indicated that Mr. Torres would use your phone to look at pornography.
Correct.
Were there ever any points in times when it was you that was used looking at pornography?
If I was, it was to go back and look to see.
Did you ever threaten to get Mr. Torres arrested if he did not do what you wanted him to do?
I wouldn't say threaten.
Okay. Well, were there ever points in times where you would like him to call you or return a call, and if he didn't do that, you would threaten to get him arrested?
It depends on if he had my keys or something that I needed from him.
Okay. And it was your townhouse, correct?
Mine, yes, flush hours.
Well, when did you get him off the lease?
I'm not sure what year it was, but I don't think he was actually removed from the lease.
Okay.
I think he was made a different type of tenant.
And did you change the locks so that he couldn't get back in at the points in times when you kicked him out?
I did sometimes.
Right. And then would you leave the key in the hiding spot that he was aware of?
There were multiple hiding places.
Okay. On any of the 911 calls, did you ever mention that Mr. Torres was aware of where you kept your keys and that's how he got back into the house?
I didn't know I needed to.
Okay.
He would never break into my home.
All right, and it's your testimony that you did not push him down the stairs, correct?
Yes,
And in fact, it was him that dragged you down the stairs the night before, correct?
yes,
Now, by dragged, did you leave your feet?
yes.
And did you get scrapes on your knees or anywhere from the carpet?
I'm not sure. I don't.
Did you get any injuries, like bruises or abrasions or scrapes?
I was missing a wad of my hair. Yes, that was on the stairwell.
Okay. And you agree that you were photographed on February 24th when the police came out, correct?
The day of the incident?
Well, the afternoon after the incident. We're not sure when he passed.
Yes.
Some of those photographs showed ashtrays inside your house. I thought you said you guys couldn't smoke inside your house,
We couldn't.
but you did, right?
Sometimes, yes.
And you agree you would go to the hospital and tell them things that were not true, correct?
Yes.
There were times where you would go to the hospital and leave without getting treatment, correct?
Yes.
And is it fair to say that you often had alcohol in your system when you were going to the hospital, correct?
Sometimes.
All right, so just to summarize the day to make sure we understand it. You all wake up sometime in the morning, but it's an unknown time, correct? On February 23rd.
Or early afternoon. Yes, I had a problem with the detectives and them having me guesstimate times.
Okay. Are you the kind of person, like most of us, that uses your phone when you wake up?
No.
So the first activity on your phone may have nothing to do with when you woke up. Is that fair for you?
Yes, other than looking at the time possibly.
Okay. So, at some point you wake up, it doesn't sound like you have breakfast, correct?
Correct.
You do some chores, correct?
Yes.
So that is true. That part of it is true. You did do chores before going to Publix at 12:17?
Yes.
All right. After chores, you go to Publix and you get that 1.5 liter Magnum bottle of Woodbridge Chardonnay, correct?
I'm not sure what Magnum is.
1.5 liters. Instead of the 750s, it's the double size. It's like 2 bottles of wine.
Okay, yes.
So you got a 1.5 liter, right?
Yes, it is the larger bottle.
And you got home, and you at 100 pounds and Mr. Torres at 103 pounds began drinking this wine, correct?
I'm guessing so. I'm not going to guess times.
Well, don't guess. I mean, you got home from Publix. When was your first drink?
I'm not sure. I mean, we could have continued to do whatever was left over from what we didn't do before we went to Publix.
Okay. So you may have started drinking even later, correct?
Then
12:30 when you get back from Publix?
I don't know.
Okay. Was it 1:30 or 2:30 when you began drinking?
I don't know.
All right. Was it before any of the phone calls to the brothers and his daughters?
Yes.
And so you drink what's left in the bottle of wine from the day before that's halfway labeled, correct?
At some point.
And then you drink 1.5 liters of wine, and he goes out and gets another one on his own without your permission or suggestion about 5:30, correct?
Correct.
And then you all consume that one as well, and it ends up in the trash can at the end of the night, correct?
Apparently.
Okay. At what point in the night does your memory tape stop? Because you described that it wasn't on at 11:03 p.m. when that photograph was taken. What's the last thing you actually do remember prior to these videos being made?
I don't recall it at this point. I don't remember.
Okay. All right, and so it ends in hide and seek after arts and puzzles, correct?
Yes.
He says, tag, you're it, but you run and go upstairs and hide, right?
Yes.
So does that mean he's it and he's supposed to come find you?
No. That's
Okay.
just,
So you both hide?
no.
Okay. How does this work?
I don't know how to tell you.
Okay.
I was it and I went and hid.
I mean, my understanding of the rules of hide and seek is one person will be it, cover his or her eyes and count to like 20 and then go find the person that's hiding. Is that your familiarity with the rules too, or do you guys have house rules?
I understand how the
Okay.
game of hide and seek
So
works.
explain to me, what was your expectation? You go up to the shower, were you expecting him to come find you?
I was.
Okay. And after a while, he did not come find you.
Yes.
And that's when you return downstairs.
Correct.
And because of the way your townhouse is set up, you can kind of see over where the suitcase is and that he's trying to hide in there, but is not successfully hidden just yet.
I mean, yes, you have to come down a good ways in order to be able to
Right,
do that.
right. But you testified that was before you got to the bottom.
Yes.
All right. And then you come over there and thinking that it's funny, you zip him shut, correct?
Yes, we both thought it was funny.
Okay. May the defendant stand down?
Entered into the well?
Yes.
Yes.
Go down.
Deputy, could we release her into the well, please?
All right. Ms. Boone, can you demonstrate for the jury where Mr. Torres' head was and how his body was positioned in the suitcase, if you don't mind?
His back was this way and his head was here.
All right, and then is it fair to say his feet are kind of down here, which would be the front left corner from their perspective in the jury box?
Yes.
And then his knees are kind of tucked up towards his face?
If I remember correctly, yes, that's the position.
Okay. All right. Can you help me understand how it was that you zipped it shut? Can you show us where you say you left an opening that his hand got out of.
Would it be easier to put it on here?
I didn't want to make you go down there. If you're happy doing that, I'll let you.
Hold up. Does she need to be wearing gloves?
Yes.
Agreed, if she's going to be manipulating it.
What do you want her to do?
Just demonstrate how she zipped it shut.
Okay, well, where's the paperclip? And do you remember which one it was in?
This side.
Judge, the paperclip was on when this event occurred. When we pulled the suitcase out earlier, the paperclip was not attached. So now the prosecutor has attached the paperclip. We don't know if that's the way it was attached.
It's not even a paperclip.
We
Okay.
don't know if that's the proper way that it was attached. But he's asking her now to pull.
Is there an objection?
Yes?
Approach. Objections overruled.
All right. Madam Clerk, are you ready? Can we see how it was that the two zipper parts were positioned when you say that Mr. Torres was able to get his hand out? If you want me to do it, I'm fine to take your direction.
From what I remember, this is how the suitcase was. This was up here. This was not this hard either. So this was like here,
Okay.
right here.
About right there, ma'am?
Sure.
I assume this one was much closer? It's not over there? Where did you leave?
You asked me where I zipped it.
When you say that it was zipped shut, show us.
Are you talking about how I zipped it, or?
When you're done zipping
the
it
hole.
shut and he's inside of it, where are the zipper components?
Just tell me where it's at.
I mean, it was the corner. I mean, it's the corner
It was
was
right
cut
here?
open. I mean,
In here?
it's not. Yes,
Yes?
this one was already pretty much, yes. From what I can remember. That's how he was coming with his hand out. It was like this from the corner part.
Okay. Thank you. You can return to your seat. Did you ever change the position of those zippers once you put it in that position?
I did not.
And so once he was zipped into there, there's some amount of time, but you don't remember specifically before you start taking the 2-minute video, correct?
Yes.
And then that's when you say what you say, and that's when he says what he says. We've all heard it, correct?
Yes.
And then between there, in that second video of the 22 seconds length, it's at this point where he's beginning to get angry, and then that's when you take the baseball bat that's in evidence, and your testimony is you start poking him with the end of it.
Did you say this was the second video?
Between the two videos, that's when you started hitting him with the bat because he was getting angry and trying to escape, correct?
Right, I was not hitting him, I was, yes.
Okay. Did you ever hit him with the bat while he was outside of the suitcase?
No.
So each time that he is hit with the bat, it's through this suitcase. And that's what leaves the marks on him because you didn't hit him with the bat outside the suitcase, correct?
Yes, if you'd like me to demonstrate.
No, that's okay. The suitcase will speak for itself. And then you take the second video and you go upstairs and go to bed, correct?
I apparently went upstairs and I used the phone to make a phone call,
Okay.
and then I fell asleep.
All right. And at the point in time when you left and went upstairs, he was still inside the suitcase, correct?
Correct.
Was he still asking for you and calling your name?
Not that I can recall.
Did you say shh to him again?
I don't remember.
Did you tell him that this was his problem and it's on you again?
I don't remember.
Did you do anything to help him escape from the predicament that you zipped him up in?
No.
No other questions?
Any redirect examination?
Ms. Boone, he just asked you the question that you poked him, and you didn't poke it. You poked, every time you poked him hard with the bat, he was inside the briefcase,
The suitcase, yes.
the suitcase. But you remember when he put his hand out, did you not hit him in the hand outside the suitcase?
Yes.
Okay, so that was the only time the bat touched Mr. Torres's body outside the suitcase,
Yes.
was when you hit him with a hand. But all the other injuries were with you poking him pretty hard. I mean, you bruised your hand, correct? Doing that. Thank you. That's all I have.
Ma'am, you can return to council's table.
Judge, can we approach you?
Just a moment. Let me get her situated at table, and then we can approach. All right, come on up, y'all. All right, members of the jury, thank you so much. It is 5:42. At this point in time, the court's going to go into recess for the evening. I thank you again for your continued service and your attention in this matter. We're going to start tomorrow again at 9 a.m. here in 12 Alpha at the Orange County Courthouse. I'll read you another instruction. I know you've heard it. I'm sure you're sick of it, but I got to keep reading it, so thank you. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, You must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to excuse you for the balance of the evening, and thank you so much. Seated. Thank you. With regard to these medical records, the court previously today had required by 5 p.m. to address those. Unfortunately, they have not yet been addressed. It is imperative that the state knows what it is we're culling down or redacting. And I understand that you may want to be seeking those into evidence maybe tomorrow, and the state needs to be advised as to what it is that you're seeking to utilize. So where are we in figuring that out?
Can I have 1 minute with the client?
Yes, sir.
Judge, we've had discussions with Ms. Boone, and she claims that every time that he went to the hospital and the medical records would show that it was in relation to some type of domestic violence involving her, we've expressed to her that we do not wish to pursue it and introduce those records of George Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that?
Okay. Ma'am, earlier we had discussed, anything else to add to that, Mr. Owens?
Just that I've explained to her that the lawyers make those decisions.
Okay.
And I believe she's in agreement now. I just wanted to get it on the record.
Understood. All right, so ma'am, I just got a couple follow-up questions, similar to other conversations we've had over the last couple of days. I don't want to know about the specifics of any conversations you've had with you and your attorneys, just whether or not you've had them. You recall earlier today I had asked you questions about certain rights that you had the ability to decide. Do you recall that conversation that we had, ma'am? It was before you testified.
Yes.
Okay. Do you recall that I advised you that the lawyers get to make most of the strategy determinations at trial? Do you recall that?
I do.
And do you recall that you said you understood that?
Yes,
And do you also recall that I advised you of certain rights that you have? Do you recall that?
I do.
And one of those rights was the right to testify or remain silent. Do you recall that?
Yes.
And did you understand that?
Yes.
So this decision is a trial decision as to whether or not there's certain evidence that your lawyers are going to seek to utilize in your defense. Do you understand that?
Yes.
Do you understand that they are exercising that trial strategy at this time not to pursue those medical records?
I do.
Okay. Do you have any questions about that?
I don't.
Are you on board with that strategy?
I am.
Are you still on board with the strategy utilized in your defense?
All of it, yes.
Are you satisfied with your lawyer's representation of you in this matter?
Yes.
All right. Thank you. State, anything else we need to address before we
My
retire
understanding.
for the evening?
Sorry.
That's okay.
My understanding is the last civilian witness they intend on calling is arriving at MCO at 9:03 in the morning tomorrow.
It was either 9:03 or 9:05, yes.
And plan will be to depose her in the evening at 5:30.
Okay.
And then, just scheduling purposes, we're trying to figure out when we would need our rebuttal expert, Dr. Werner, to appear.
I know Mr. Owens had said they were endeavoring to finish by Friday, but I don't know if Dr. Harper's availability issues for tomorrow is going to change that anticipated timeframe.
I'll try to reach out to her by text. That's usually how we communicate. But,
Well, assuming she testifies on Thursday, are you still in a position to rest on Friday, or would that kick us to the next week, sir?
well, no, I want to finish this week if at all possible. I'm hoping that Dr. Harper could be here tomorrow when Dr. Brandon is here, but let's just say she's tied up in Bay County.
Let's do worst-case scenario.
Okay, she's here Thursday morning. I think we would try to finish our case right then and give the state a chance to rebut. I would say Thursday. I would have,
Tim, my understanding is our expert can't be here in the afternoon on Thursday. I'm going to have to check her availability for Friday.
If you would be so kind, and we can address that tomorrow morning.
Thank you.
Okay, anything else, state?
Not
Anything else from the defense?
no,
All right, the court will be in recess till, yes, sir.
I'm sorry, just to give everybody some scheduling, this might help everyone's schedule. There are going to be 2 officers here in the morning who are going to be ready to testify. There will also be some other witnesses, officers, like the detective who testified, that I need to call back because of some impeachment issues of one of the witnesses. And then we'll get into everybody else's witnesses. So there's about 3 or 4 that I have in the morning time that we'll be proceeding on. Then we'll go from there.
Okay, all right, appreciate the lay of the land. All right, we will see you all, one more, Mr. Owens, yes, sir.
This flying in from New Jersey, I think, is Wednesday at 9 a.m. I think the flight, she's scheduled to fly out Thursday at 9 a.m. So if there's any way we could depose her, maybe in the morning or at lunch, and then have her testify Wednesday afternoon?
That's an unreasonable demand on my time, given everything I've been doing to make sure that we can get this pushed through. I need to do things like get ready for expert cross-examinations, and other things need to get accomplished at lunchtime. Happy to do it in the evening. My understanding that she was supposed to be coming in today so that we could do it tonight, and that didn't happen. But I don't think I should be forced to accommodate a lunchtime deposition.
Anything further?
I'm just telling you what our plans were.
Deposition will be at, 5:30 tomorrow, or at any other, if we got to have it later, depending on how we go. We'll address it at that time. All right, thank you both very much. We will see you tomorrow morning at 9 a.m. Court's in recess.
Well, guys, there's day 3 in the wrap. I was getting a little worried for a minute. So,
All the reviews say, oh.
so we'll pick up in the morning with day 4, I guess. It's getting a little different than the way I thought it was going to go. So, girl, you have a good night, and I'll talk to you in the morning. Here's the outro.